Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention. You shall be heard. God save these United States, great state of Florida, and its honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. The first case for the day is Young versus Achenbauch. You may proceed.
Good morning, and may it please the court. I'm John Mills on behalf of the petitioner Flight Attendants Medical Research Institute, also known as FAMRI, and I will be speaking today on behalf of all three petitioners, Patty Young and Lonnie Blessard as well. The issue presented today is under what circumstances, if any, a Florida lawyer should be allowed to take actions against current clients or against their interest in closely related matters. The district court's decision overturned the trial court's decision and found that the trial court departed from the essential requirements of the law by applying the conflict of interest test this court has set forth. The district court said that that was a departure from the essential requirements of the law because this court's rules and precedents are inadequate in the context of class actions. First off, the district court has no authority to find this court's precedents inadequate. This court has made clear that these conflict of interest tests from the rules of professional conduct govern motions to disqualify, and it has also made clear in the Adorno case that those rules apply in the context of class actions. But this court, of course, has the authority to say that it made a mistake or to change the rules to adjust them for unique circumstances of class actions. The reason that the district court found these rules to be inadequate was based on federal law, and it adopted a federal balancing test, which it found that the trial court abused its authority by not applying this new federal balancing test. But the federal balancing test arises in circumstances that are just not present in this case. That case law addresses motions to disqualify class counsel when counsel has been representing the class for many years, negotiates a settlement, and at the settlement proceedings, a minority of the class members object and move to disqualify the trial lawyer. The federal courts say that allows a minority of the class to hijack class counsel and that it's not workable, and therefore there should be a balancing test that balances the actual prejudice, any confidences that were disclosed by this minority of class representatives, against the right of the majority to have the same counsel. That doesn't apply here. Mr. Gerson and Mr. Hunter never represented a class. They never negotiated a settlement agreement. This case does arise from a class action, but that class action was settled long ago and dismissed with prejudice.
So who are the attorneys who are being disqualified or asked to be disqualified are representing individual members who were a part of this class?
That's correct.
And those members were a part of the settlement agreement. Is that correct?
Well, the class was a party to the settlement agreement. So yes, as members of the class, they were parties to the settlement agreement.
And were these attorneys representing those individual members at the time that the settlement was reached?
No, they were not. They came on, Stanley and Susan Rosenblatt were class counsel. They negotiated a settlement agreement that provided for kind of progeny actions like the court is familiar with in Engle, where the class was thrown out, was dismissed, and the individual members of the class were authorized within 1 year to bring progeny lawsuits, which are their individual lawsuits where they have to prove up their claims. They gave up the right to seek punitive damages in exchange for the defendants giving up the statute of limitations defense.
But they all agreed to, as members of that class, they agreed to this settlement which formed the foundation.
Yes, that's correct. Notice went out to all class members with an opportunity to object. A very small handful did object, mainly on the basis that they weren't getting any money out of the settlement agreement. And we have the Ramos opinion from the 3rd District that said that doesn't matter.
Here's what my concern is greater than what test is applied. Reading your briefs, it appears that it's not just an issue of these attorneys and their clients representing somebody who now is suing someone they represented, basically. But that the course of conduct that the attorneys are involved in sounds like it is destructive of the settlement agreement. So was that part of the calculation, because you bring in all these other things that concern me greatly, was that part of the litigation to disqualify these attorneys in the trial court, and how did the third district address that?
Sure.
Because again, this is a little different than just your ordinary, in my view, ordinary conflict.
Absolutely, absolutely it is. And I think these other aspects of misconduct in this case, we're not throwing them out there to besmirch anybody. They are directly relevant to the disqualification issue. They were raised in the trial court. They were raised in the district court. The trial court found conflicts with current clients and also with former clients. So let's talk about the current clients. There are 4 categories of current clients, and it's the last category where all of that stuff becomes so relevant. But let me just, if I could build up to that. The first category is, of course, their clients who filed affidavits in this case. Ms. Young, Ms. Blessard, we also had Awareness, Chambers, and Spurgeon.
Well, this is what you set forth in your reply brief.
Okay, so we've got.
I mean, you can go over it, but so if you.
Well, the last category is their own clients, their own direct clients. Even if you put aside all this team approach that the lawyers had a team approach and represented, putting all of that aside, we know that they asked their own clients to authorize this petition belatedly. The majority of their clients declined to do so, but a minority, a substantial minority, signed this solicitation letter, which is in the record, agreeing to come in. But there's a conflict even as to those people who authorized this suit, because to waive a conflict, you have to have informed consent. And the way we know their consent was not informed is because they were advised of this in a solicitation letter, a status letter in their individual lawsuits.
So I guess maybe this is it's an overarching question. Say they find a lawyer that hasn't been representing the class or didn't represent people at the time of the settlement or subsequently to bring this lawsuit.
Right. And they have done that. There is a separate lawsuit now through a new lawyer. That was in the state proceeding.
And so it's really not the propriety of the lawsuit, but the fact of who they represented before that should be before us. So I guess that's what
Well, that is true, but the reason that is relevant is because their own clients, when they got their own clients to waive this conflict, it was not informed consent, because their advice that they gave, which is the whole reason this lawsuit is here, is so rife with false statements and misleading statements. It does show why the merits of the case, there are no merits of the case. But more importantly, for our purposes, it shows why when these clients signed the letter saying, okay, go ahead, that's not informed consent.
Well, how do we know that in this record?
We know that from the letters themselves were filed. And what happened was they filed the petition. We have the background that for about a year leading up to the petition, beginning in early 2010, the petition was filed at the end of 2010. Mr. Hunter and Mr. Gerson engaged in this more and more aggressive approach of trying to liquidate family, different ways that we can get money out of family. That family said, we can't do that. We have tax laws that prevent us from giving money out. We're a nonprofit. And we have a settlement agreement that the 3rd District made clear we can't pay money to these individuals. So they file a lawsuit. They file this petition. After they file the petition where they don't name anybody they represent, you can't tell in anything they filed in the trial court who they represented until well after. You can't tell in this court. They don't even list who their clients are right now. But they did in the district court. And those people are people who signed these solicitation letters after it had already been filed. The solicitation letter says, if you'll sign this, that'll authorize us to file a petition. Doesn't tell them they've already filed the petition purportedly on behalf of these people, the majority of whom did not authorize it, even belatedly.
But how does that shows further questionable conduct, which I'm sure there's another explanation, so we're not accepting, I understand what you're saying. But how does that affect the threshold issue of the conflict of interest?
Well, the threshold issue is...
Because filing something without the authority of your client is a whole other issue that would give rise to ethical violations. So how does that relate?
It's relevant to show that what they're doing right now is adverse to even these current clients. We have to show adverse. It's clearly adverse to the members of the board who are their clients because they're the ones being accused of misconduct. It's clearly adverse to the people who filed affidavits who explained why they don't want family taken away from them and why the settlement is important to them. But to understand why it's a conflict even as to their existing clients today, that's not apparent from the face of the record.
But you're saying another group of lawyers have filed the identical lawsuit. Is that correct?
Yes, they have gotten, another law firm has filed a lawsuit. It's been dismissed.
So the same problems will arise. You're just saying these lawyers, because of their particular status, can't be the ones to prosecute.
That's right. And it was a smaller subset of these current clients who filed that lawsuit. And yes, one of their clients could determine, hey, I'm not getting anything out of these lawsuits. I do want to raid family. I don't think it benefits me at all. I do want. They're entitled to do that, and there wouldn't be a conflict in that point.
Let me ask you this about the family foundation. I thought it was my understanding that if the funds that go into that foundation are not used for the purpose of medical research, isn't that what the purpose was, that the whole settlement falls apart? And so how does it benefit these clients to do this?
It doesn't benefit them. If the money, if family were, or if this petition were successful and their lawyers got what they're demanding, which is an order that families send funds to these people, the tobacco companies, they have already filed a response that said you can't do that. The settlement agreement itself says if you modify it, it becomes void and the parties are returned to the status quo. So they will not get the money. If it gets undone, the money would go back, I guess, to the tobacco companies. That will never happen. It's a meritless lawsuit. There's nothing that's ever going to happen. But if you take their allegations and what they're seeking to this natural conclusion, that's what happens. And that's against all of their clients' interest. Because now they lose the individual benefits of these individual lawsuits where they are allowed to sue the tobacco companies because the tobacco companies sold somebody else cigarettes that they smoked.
But you don't want, in the discrete issue in front of us, I guess these facts show why you're urging us not to apply the federal balancing test because it's not warranted under the facts of this case. Is that what I understand?
Yes.
But as far as whether this is a meritless lawsuit, that is not an issue before us.
It is not an issue before you. Again, and I don't want to keep arguing. If you don't want to hear any more about it, I'll be quiet about it.
No, I asked you some questions about it because it concerned me that the effect of this could be what you just explained to us could be.
Right.
But you also said there's another lawsuit going on. I presume this lawsuit, I mean, what is the status of this particular lawsuit?
This particular lawsuit, a petition has been filed. We filed, I think, a motion to dismiss it, arguing why there's no grounds for it.
Because right now, they're in the case, right? Is that correct?
Their clients are. Before a ruling, before proceedings on the motion to dismiss, we had the motion to disqualify their counsel. That was granted. These lawyers, there's an order that says they can't represent the clients in this case. That order's never been stayed. They're violating it by being here today.
Isn't that what the 3rd District reversed, though?
It did reverse it. And we moved for a stay here that said stay the 3rd District's decision.
Did we?
And you granted it.
Oh, okay.
You did. You granted it. So the trial court's order is not stayed. The trial court's order says they don't get to participate in this. Now, at the trial court, they had an independent lawyer representing them. Mr. Reyes represented them in the trial court, but he isn't with them anymore. They filed the petition. These lawyers who've been disqualified filed the petition on behalf of the clients. There have been a court order says they cannot represent. They filed a petition in the 3rd District. The 3rd District granted it, and we petitioned here. You stayed the 3rd District's decision, and the stay order makes very clear that that disqualification order is still in place. If these clients really want these lawyers here as opposed to the other lawsuit, all they need to do is hire a lawyer, Mr. Reyes or whoever here, if they can find somebody who thinks there's any basis to this cert petition they brought to the 3rd District. They could have hired them. They did not do that. There is no basis for their claims here. This is clear. You shouldn't even have to get to the former clients. But the 3rd District did say they don't have any current clients with conflict. 3rd District took a very narrow view, did not look at all the impacts to all the other people, just looked at Ms. Young and Ms. Blessard. Said, well, Ms. Blessard was the only one directly represented, and they dropped her as a client. So she's a former client, so now we do this test under 4-1.9 for a substantial relationship. You don't ever need to get there for a lot of reasons. But if you do, these cases are substantially related. All you have to do is look at their petition. The petition in this case has a whole section of it is devoted to the individual lawsuits and why they say their clients can't win the individual lawsuits because their claims can't be proven. So they're coming in here, filing a petition, throwing all the individual litigation under the bus and saying that's a reason they should get more money from the settlement agreement because it was a settlement of claims that nobody can win. That's what we're here. It's through the looking glass. I'll reserve the rest of my time.
Thank you.
May it please the court, my name is Philip Gerson. I represent the 260 flight attendants who were class members who were named in the petition for certiorari before the 3rd District Court of Appeal.
And how many class members were there?
That's never been made clear.
Well, is this a majority of them that you represent or that you currently represent? And well, I filed approximately 600 lawsuits. But I guess, and the question, can you address the fact if the order was not stayed preventing you're one of the lawyers that was precluded from representing these clients, is that correct?
That's correct.
How are you still representing them before us?
Well, that order was appealed.
But is Mr. Mills correct that the order was stayed?
Well, here's a more accurate procedural history. A petition for certiorari was filed in the 3rd District Court of Appeal, and the 3rd District entered an opinion granting the petition. After the petition was granted, the respondents moved the 3rd District for a stay order. The 3rd District granted their motion and entered the stay order. Then this other lawsuit was filed by another lawyer I don't know. Since my hands were tied by Judge Bagley's order, I've done nothing more in the trial court, nor has Mr. Hunter. But another lawyer filed an action on behalf of the entire class, and that case went before Judge Bagley. Judge Bagley dismissed that case. I know nothing about it. That is on appeal.
How does that affect this case? Because we're here on this case, and in this case, it seems that you were disqualified, and that order of your disqualification is still in effect since we stayed the 3rd District's opinion that said you were not disqualified. So that's why I'm trying. How does the subsequent lawsuit affect your disqualification?
Well, what I was about to say is that after the 3rd entered that stay order, we learned that this other lawsuit had been dismissed based on what would happen in this case, and we brought that to the attention of the 3rd, and the 3rd lifted its stay. After they lifted their stay, then the moving parties asked this court to enter another stay.
Let me get you to the merits. Why don't you have a direct conflict here?
Well, plain and simple, I don't represent, nor was there any reasonable basis for concluding that I ever represented Ms. Brizard or Ms. Young. The client of mine, the one client of mine who is directly focused on by them, let me know that she didn't want me to go forward from this, so I withdrew from her case. What's been called the solicitation letter is simply a letter that says privileged and confidential that I sent to my clients. How it got into their hands, I don't know. That was never made clear. And it pointed out the weaknesses in the litigation before against the tobacco companies. And instead of taking that letter to the trial judge and saying, Judge, by whatever means we've come across this letter, they just published it in the record and served it on the tobacco companies.
The disqualified lawyers are you telling me do not have former clients in the class that entered into the settlement agreement?
No, we do have clients who entered in the settlement agreement, that were part of the class that was covered by the settlement agreement. But they're not getting what they were promised in the settlement agreement.
Did you have discussions with the other lawyers who represented members of the class while that litigation was going on?
Not the class litigation, no. This subsequent lawsuit, no. I've had no contact with them at all. Don't even know who they are.
While the class litigation was going on before the settlement, you had no discussions with the other lawyers at all?
None.
No team approach?
Well, I'm not sure what you're asking me, Justice. At the Brewing class action, I was not involved at all until the year 2000, long after this was all done. So I had no discussions with anybody. The subsequent case after our disqualification that was filed in the circuit court that went back to Judge Bagley, was dismissed by Judge Bagley, and is now on appeal to the 3rd District Court of Appeal. I've never had a conversation with that lawyer.
Before. It seems to me if you're representing clients who, and you engage in discussions with other counsel who represent class members who are in the same position as your clients, and you're having communications with them about strategy and what's going on in the litigation, then you use that information subsequently to the harm of your former clients. That seems to me to be problematic. Is that not what happened here?
No, that's not what happened. We didn't use any information to the harm of any of our former clients.
That's not the test. The test is whether confidences were shared. And the trial court, in quoting from the affidavit of Blizzard. Now, did you represent Blizzard?
No, I didn't.
Okay, well, she says these attorneys acted as a team, and other class representatives, Patty Young and Lane, shared many confidences with them about ourselves and family. I worked most closely with Steve Hunter, who is your co-counsel, but I also worked with Philip Gerson and Marvin Weinstein as I trusted these members of my legal team. Now, that you're contesting that, but the judge made those determinations in an order, and I didn't find that the 3rd District found that those were lacking in the record. No one offered to put in, you didn't put in a counter affidavit, so aren't we left with this as being the team approach, that there were confidences shared, that these actions are directly contrary to the wishes of some of the people who shared confidences with you and Mr. Hunter?
There were contradictory affidavits, and they're cited extensively in our brief on the merits in this court. And all of those allegations were disputed and refuted.
But I guess here's 2 things. First of all, there's no evidentiary hearing. So this idea there's conflicting affidavits, no one asked for an evidentiary hearing. But more importantly, the law on conflict of interest and the ethical conduct rules do not require there be actual harm demonstrated in order to be able to represent a client who, or against a client who objects to the representation. Am I missing something? Does there have to be actual harm?
There does have to be actual harm, and in this case, there is none.
So
nor was any ever demonstrated.
I just want to make sure you're saying the conflict of interest rules allow you to represent against a former client who was your client, and you can represent that person even though there's a conflict of interest, as long as there's no actual harm to the client. That the client has to demonstrate there were confidences shared that would harm that person. Where's that test?
No,
okay,
no,
so then,
I'm not saying that. I'm saying I never represented Broussard or Young, despite what's in their affidavit. And there was a conflicting affidavit that I filed that set forth our factual position. We had no burden of proof on the motion to disqualify. If there were conflicting factual positions that were presented to the trial court, it wasn't our responsibility to insist that testimony be taken. Our position was that as a matter of law, the motion to disqualify us was flawed and should be denied.
Did you file a lawsuit for either of them that you just mentioned?
No, I never filed a lawsuit. I never appeared in any of their lawsuits. I never had a phone call with any of them. All I ever did was have casual conversations with them at a couple of Mr. Rosenblatt's weddings. And we've cited the cases that support that that is not an adequate basis for an attorney-client relationship to be inferred by an appellate court. That's the Bartholomew case, the Eggers case, and the Effman case.
But that's not what the third district didn't quash the trial court's order on the basis that there was never representation. They went much broader and talked about even if there's representation, there's a balancing test. So that's what I'm having. I mean, what was your position before the third district?
Our position before the third district was that they were not our clients.
Well, that
that
would
there
have
was
been
no
an easy-
reasonable belief on their part ever that I represented any of them merely because I met with lawyers who had a common interest.
But
Did Hunter ever represent them?
I beg your
Did
pardon?
Hunter ever represent Mr. Broussard
Yes.
for 10 years?
He was her attorney of record for, I guess, 10 years.
Okay.
Okay, but I never represented either one of them at any time. And I never withdrew from their representation because I'd never appeared
So is your
on their
position
behalf.
then different than Mr. Hunter's position? Are you now saying it was wrong as to you, but not as to Mr. Hunter?
Well, what I didn't say is that I want to save half the time for our side for Mr. Hunter to state his own position, but my position as to myself is I was never attorney for either one of them.
Is he going to argue?
Yes.
All right, let's hear from him.
Okay.
They didn't say they were going to give it time.
Justice Paulson and Justice Pariente and Justice Quince asked the questions, also Justice Perry, but let me give a historical explanation here because I know that from reading the third district opinion, it may not be clear to you. The class action was settled in 1997, and there was a preliminary fairness hearing following the settlement agreement before Judge Kaye, and then there were objectors. Judge Kaye approved the settlement. Objectors came forward, and then there was then that was the Ramos decision. Ramos overruled the objections and affirmed the settlement, and they modified the settlement, but it's the Ramos opinion that this case is all about. We're trying to enforce the mandate in the Ramos decision. Now, that was in about 1998, 99, I forget the date of Ramos. None of us were involved. None of the lawyers who, Mr. Gerson, myself, Mr. Alvarez, none of the lawyers, the other lawyers were disqualified was Mr. Abedin, Mr. Smith. None of these lawyers had anything to do with the clients. In the year 2000, as a result of the settlement agreement, which allowed individual flight attendants to go forward with individual cases which would only involve medical causation and damages, we undertook to represent those clients in those personal injury cases against tobacco. And similar to the Engel cases, the only thing we took on...
You saying we? Who is we? Identify who?
Well, Mr. Gerson and I,
Okay.
Mr. Alvarez, and some other lawyers, but there was a team of lawyers. Now, the team approach that's been referenced in the briefs was a team approach in our cases against tobacco. So we shared information in the cases against tobacco. We were trying to prove medical causation and damages. And medical causation in a secondhand smoke case is extremely difficult, and it was very hard for us, and we were totally unsuccessful. We won one case. Mr. Weinstein and I tried one case, we won one, and we lost 10. because it's not like a direct smoking case. To prove medical causation for a specific person is monumental, and we lost all the time. I mean, I hate to say that, but we did. We couldn't win them. Now, during that representation, during that period of time where we were representing these clients in their individual cases against tobacco, which had nothing to do with what we're here for, had nothing to do with the fund, it had nothing to do with anything except proving cases against tobacco. Some of the lawyers involved in representing the people against tobacco began to think, boy, we're not doing well here. Let's see if there's a way we can get what's always been everybody's desire, and that is to get money into the hands of our clients. And that started out in the record.
And that way to get the money into the hands of your client was to disrupt the settlement and get the money that was in the settlement to get to your clients?
Well, it was never formulated. The original designer of the plan was Mr. McGrain. And as he says in his brief, the way he describes his efforts, this was not my idea. It was Mr. McGrain's idea. And what he says in his brief is during the extensive pre-petition period, and this is his brief in representing Ms. Young, he says, during the extensive pre-petition period, while the undersigned counsel was part of a team of flight attendants counsel seeking a way to end the flight attendants litigation through disbursements from FAMRI. Now, I didn't come up with this.
I thought we were here because you guys are trying to get money from the family or whatever it is, the settlement.
That's the way it's been characterized. But
that's not what you were trying to do.
Well, no. Let me be very, very clear about this.
But let me ask you another question before you answer that. Now, was not Mrs. Blizzard and Ms. Young on the board members of this nonprofit?
Yes.
That you were trying to dismantle?
No, I'm not trying to dismantle that.
Well, if you get money from them, the lawsuit goes away. I mean, isn't that the crux of this matter?
No,
Okay.
I don't believe it is. The crux of the matter is to enforce the mandate from Ramos, which required two things, which have never been done. Medical treatment for our clients, which has never been given to them, and to restrict the research for the benefit of flight attendants as opposed to other good works, such as the people in Haiti that suffered from the earthquake, and to narrow the research.
Well,
now,
I guess because you're telling an important history, and I want to make sure that I understand what you're saying. Are you saying because you only represented Ms. Blizzard and others in suing tobacco that there is no conflict, even though these former clients don't want you to sue FAMRI, and you're suing FAMRI? Is that what I'm understanding? That you're saying this is a distinct issue that shouldn't ever give rise to a conflict of interest?
Well, first of all, I've never sued FAMRI. I'm not suing FAMRI. I'm just filed a petition to enforce the mandate.
They're the opposing parties here. They're the ones that sought to. I'm asking you that question. Are you saying because you weren't with the Rosenblatts pre-1997 in negotiating the settlement for the class, and you only sued on behalf of individual members, even though some of those individual members now object to what you're doing, because there's not a relationship, that there's no conflict of interest?
Well, yes, I represent individual people.
But did you represent Ms. Blizzard?
Yes, I did.
Okay. Why is there not a conflict of interest in her objecting to what you're doing, which she sees as being adverse to the position that she wants to take?
Because I faithfully adhered to our rules of conduct concerning a conflict which arises when you represent multiple clients, and unforeseen to you, a conflict arises with one of them, The comments to our rules say that the first thing a lawyer should do is withdraw from the objecting client, which is exactly what I did. And then it wasn't until many, many months later. I'm sorry.
Yeah, so you're saying the third district really got it wrong because they should have found there was no conflict of even under our rules. Is that your position?
Well, I think they did apply our rules.
I'm sure you would not know. I mean, this is something that I'm hearing you talk about it. But the trial judge found there was a conflict, and I'm just really having a hard time understanding why that judge's order isn't a correct statement of an interpretation of our rules of professional conduct.
Well, let me answer that question specifically. The trial court's order, the standard the trial court's order has clearly erroneous factual findings. And I understand for this court to overturn the trial court's findings of fact, you have to use a clearly erroneous standard and show that there's a palpable misconception of the facts on the part of the trial court. But the trial court's reasoning that our representation of our clients against tobacco in the medical causation and damages representation, we said that was totally unrelated to anything now that is proceeding before this court. That the trial court here's what the trial court wrote in his order at 1817 of this record. He goes, at the core of petitioner's counsel's prior representation of Blessard and Young are the funds that are central to the current litigation. Now, that's just wrong. My representation of Ms. Blessard had to do with her suit against tobacco. It had nothing to do with the fund. It had nothing to do with FAMRI. It had nothing to do with her membership as a board. She was represented by Mr. Petrie or by in association with Mr. and Mrs. Rosenblatt. I had nothing to do with FAMRI. I've never done anything with them. I don't know anything about them. I'm not attacking them.
And she never shared with you any information about her work with FAMRI during the course of that 10 years?
No, sir.
Okay.
I mean, I know she's a board member. She was my client. I mean, I know that, but I'm not knowledgeable about anything. I have no specific knowledge about anything that FAMRI has done or hasn't done other than as this case proceeded. Now, one thing I want to do is...
She was a board member. She is a board member, and she was your client.
Yes.
And aren't you trying to, through litigation, undermine the actions that she's taken as a board member to say that they're inadequate?
Well, at this point in time, yes.
Yes?
Yes.
Why isn't that an absolute conflict?
Because once I withdrew pursuant to the rules, that I can thereafter, which is what I did. The rules say that. The rules say that if you discover a conflict, the lawyer is instructed to withdraw, and then at that point in time, the client becomes a former client.
I don't know that the rule was intended for this situation for you to be able to pick and choose and cherry pick once you see you've got a conflict. But I'll certainly look at that. But I don't think that's that's how things are allowed. That all of a sudden you realize, well, I'll take the one I like and I'll just dump the other one.
All right, let me speak to that issue because that's important, because that's why the Third District Court of Appeals discussion of the Lazy Oil case, although that involved a class action, we have to understand here, I represented Ms. Blessard and another 300 people. And during the course of that representation, I represented them all for 10 years. And I'm not cherry picking anything. I mean, I have these clients. They're all my clients. And then at one point in time, she came forward and said, I object to this, anything which could involve taking money away from the fund.
And the record shows all 299 other clients consent to this
Absolutely.
action?
I've never, there's no objections except for 5. two of which are the people that I think we're here for, which is Ms. Young and Ms. Blessard. They have come up with three others, but of all the rest of the people, nobody else has objected to this. Now, let me talk about whether
I'm having
family
trouble
is
understanding why it's still not a related matter. Because basically what you're doing, you're saying you're suing them for the tobacco companies, but suing the tobacco companies for them. But now you're changing your target and going after this fund that was created in it's part of the class action result that spawned all this. It just seems to me that all of this is intertwined, and I'm struggling with understanding how it's not related. It's not a related matter.
Well,
help me with that.
Okay, I will. The Third District Court of Appeal found it's a different issue, and it really is, because our case is against...
Well, we're kind of beyond, we're looking at whether they were right. So reliance on what they said doesn't really help. It helped me independently understand why it's not related.
Because, first of all, the cases against tobacco are just medical causation and damages. And the case now that's before you is to enforce a mandate in Ramos, which we contend has not been followed. But whether or not we're able to get monies into the hands of the flight attendants is not something that I have any control over. I don't have a right to a jury trial. I don't have a right to convince anybody of that. I want the court to understand that, which I think has been overlooked. This is a class action, and there is, although they contend they're not class counsel anymore, the class was never decertified, class counsel was never discharged, and the voluntary or the dismissal with prejudice was not of the class. It was of the case against tobacco. This was a class action settlement which set up a fund, which was supposed to be under the direct supervision of the court. And class counsel made those representations in order to get the case approved, and the representations were that they would continue, and let me quote from it, that they would, you have our brief, Chris? These were the representations that were made to the Ramos court in order to get them to approve the settlement of this class. That the foundation is not a charitable foundation. The foundation will be directed and supervised by the trial court, not class counsel. And just as guardianships proceed under the continuing supervision of the Dade County Circuit Court, the $300 million Flight Attendant Foundation will be under the continuing jurisdiction, guidance, and direction of the Dade County Circuit Court. Now, that has got to be the case because this is a class action that set up a fund, and the court has a continuing jurisdiction and under its equitable powers to supervise that fund. Now, if I were to ever suggest anything which threatened the fund or did anything which was in any way contrary to the interests of the class, the court is the father of the class, and class counsel is got the fiduciary obligation. So I don't have any control over that. Now, is there some suggestion that we would like to transfer funds? Was there a tremendous amount of effort in order to do so in a way that would protect family and protect everything? We always did that. If you look in the record of 645...
I'm wondering, I'm beginning to see that we're approaching a play on words here, it seems. And my concern is that you keep saying we're here to enforce the mandate. Did the underlying settlement provide for dollars to be distributed to the flight attendants directly?
No, sir.
Well, again, then, when you say, then I'm trying to find a way to force them to pay my clients for their medical care, that seems to say, you may use whatever words, but it seems to be saying I'm trying to modify the underlying agreement.
No, Your Honor, let me...
Okay, please help me understand, because that's
Okay.
what it sounds like you're saying to me.
All right. In class action practice, as I'm sure you know, that the parties will enter an agreement. The settlement agreement entered into between class counsel and the defendants is then subject to approval by the trial court. Unless it's approved, at first there's a preliminary fairness hearing, then there's a fairness...
I understand all that.
Okay,
Let's get past that.
But then, once that trial court approves the settlement, the settlement agreement entered into by the parties is overcome by what is approved by the trial court. That went up to the Third District Court of Appeal in Ramos. Now, the opinion in Ramos is what controls. It's not the settlement that was entered into between the class counsel and the defendants. It's not...
Okay, so you're saying it's different.
Yes, and let me quote to you what it is.
All right.
The medical foundation would provide treatment to mitigate diseases affecting many class members. And what we're saying is they never did that. They never provided any treatment for our people.
Are you saying that the third district's opinion modified the agreement that had been approved by the trial court?
Yes, sir, absolutely. There's no question about that. It's the approval that controls, not the settlement entered into between the parties. It's what was approved by the court.
That seems a little odd, Mr. Hunter, because you're suggesting that in class action litigation, that a settlement can be entered into by the parties and then changed by the court.
Yes, sir.
Without the agreement of the parties.
Yes, sir. They appealed it. R.J. Reynolds R.J. Reynolds appealed, and they said this approval in Ramos is different than what we entered into.
And what did the third district
said is
said?
the treatment. We didn't agree to provide treatment, or we didn't say that these funds could be used for treatment, and their motion was denied. Rehearing was denied. Ramos is what we were living by. It's not what they agreed to, it's what the third district did in Ramos. And then what we're coming forward to and saying it never happened. This was supposed to be a fund that was supervised by the court. It's the only class action in 21 years of doing class action work. It's the only fund in anywhere near this size which has never had court supervision. Even though all of the things which got the court to, the foundation is not charitable, the foundation will be directed and supervised by the trial court, it's never been...
Well, I mean, that's way beyond what we're here to
I know,
to
because
talk
I
about.
thought we were
But
here
so
on,
then the claim,
conflict as
may I
two
finish?
clients.
So the claim that you're attempting to assert is that lawyers representing members of that class do have a right to file an action against the entity holding the funds to enforce and receive proceeds from that are not being distributed, and it is not a conflict to do that. That's what you're saying.
Yes, sir. Yes, sir.
And in so many words, that's it. That's the sum and substance of it.
Yes, sir.
And they're saying, but it is so related and intertwined that when you start representing those folks who've agreed to apparently that maybe the terms of the settlement, I guess, become the focus here, but that is the conflict. That's the legal issue we have to decide right at that point.
Well, yes, I mean, I think you have to realize that I'm not conflicted because I represent individual people. None of my people have objected to this. Nobody in this class has objected to us trying to enforce. Now, whether or not any funds are going to go to flight attendants,
You have well exceeded your time. I've given you substantial additional time, frankly, because I think that this is perhaps a serious additional bar discipline issue from my perspective. That's the reason I wanted to have the opportunity to hear you explain this with more time. So that's the reason I allowed it to go on. Rebuttal?
Thank you, Justice.
I'm not going to have time to show to you that you just heard at least 20 just false statements that are against this record and against what they know to be the case.
Well, do we need an evidentiary hearing then with the bar counsel sitting there trying to figure out who's telling the truth?
Well, at some point, that's not for this case, that's not for me to do, and I'm going to try to focus on just what's relevant to
peel
this.
this onion just a little bit. Do you agree or disagree that the third district altered the underlying settlement?
I completely disagree. The third district has said in the French case that they did not. I'm sorry.
the opposition says that's the key here, is that the third district altered that term to require that there be funds available for treatment. And somebody's got to be able to enforce that treatment provision, and that there's no conflict on their side because that's all that they're doing. And that's, so just start right there and help
Yes,
me. Maybe I'm trying to perceive it in much too simple
No, I think that
terms.
I think that that's an appropriate way to proceed. I think that is their claim, and it is utterly false.
Okay, explain to me why.
The
please.
settlement agreement itself says it cannot be modified, and if it is ever modified by any court, it becomes null and void.
Okay,
and the
now that's
parties
where they say they're not modifying it, they're seeking to enforce
Right.
just the treatment provision of it.
Okay. So the settlement agreement says it can't be done. The third district itself has said in the French case, which we cite in our brief, that the agreement was not modified. We proved it, it was not modified.
So the treatment clause that he's suggesting is in Ramos, that's where we're going to have to start reading this to see
There
where
is
we are.
no treatment clause. There's nothing about treatment. What happened was there was discussion.
Wait a minute. I'm just about where the Chief Justice is here. He said he even filed a petition for rehearing. Did Tobacco file a petition for
Yes,
rehearing?
Brown and Williamson filed
saying that there was no provision for treatment of any of the flight attendants in the class settlement.
Yes, they did. And there is not, and they were correct. My point is the third district, as it has said afterwards, did not do what they're saying. It did not modify it to suddenly require medical treatment. What they were doing, they did refer to medical treatment, is they just said that this foundation will benefit the class because it's providing research that is going to lead to treatment. And it does provide some treatment. They've had screening centers since 2002 in San Francisco, it's all in the record, that flight attendants, other people can go to because tax laws can't limit it to just certain people because it's a nonprofit, but that they can go to and get screened for this. The tax laws prohibit direct benefits. We can't give them free treatment. Nothing in Ramos said we were going to be directly providing free treatment. We're a research foundation. We provide research that leads to treatment. That benefits everybody, indirectly benefits them. And the whole point of Ramos was even if it didn't benefit them at all, the settlement agreement is still fair because the tobacco companies never would have paid anything to them. They were about to lose all of their claims. All of these ladies' flight attendants' claims are time barred, or almost all of them, and yet they've got this big settlement. That's what Ramos was about.
Let me ask you, he says that there's no conflict because they withdrew.
You cannot escape. That is based on a bar rule that says if you represent two clients, and when you start representing them, you don't have any way to anticipate that they're going to have conflicting interests, and something happens, then you withdraw, and whether you can stay on for one or the other depends on whether it's substantially related. You go to the former client test. It doesn't happen where you caused the conflict. They knew in 2010 that a lot of flight attendants did oppose this. We've given letters from their clients saying, don't do this, don't do this. Lonnie Blissard said, Mr. Hunter, you're my lawyer. How are you doing this? I've given you confidential information, and now you're saying you're going to file a petition claiming me of misconduct? That was all before he did that. And he did it anyway. No client asked him to do that. This isn't something that came up because clients said, I want to sue other clients. He did. He wanted to sell his client under the bus and sue her, and he did. He filed a petition against the very board she's on saying she mismanaged it, and he says that's not a conflict because when she said, hey, you can't sue me, he withdrew from her case. We can't do that as lawyers. We can't do that to our clients. That's absurd. It's obscene. This notion that even if the settlement agreement was modified and Ramos modified it and now there's some new mission for family, yes, the court reserved jurisdiction to oversee how this fund was administered, and it did that. The fund was administered by the creation of family. Family didn't exist at the time of the settlement agreement. It was created. The court appointed an attorney ad litem who came up with the best way to do the foundation and said it's a nonprofit, and here it is, and here's the articles of incorporation. And there was a hearing, and the trial court entered an order that said, I approve the formation of family and the people on its board, and I hereby release all restrictions on the funds. So the court did have jurisdiction to oversee it. It did. It did its work. It approved family's mission statement, which is what family does. And if a nonprofit is not doing what its mission statement requires it to do, the law says it's not for some court in a case that's been long dismissed that released its jurisdiction, it's for the Attorney General. The Attorney General has the statutory authority to make sure that a nonprofit is doing what it's supposed to do. So the Attorney General could bring a claim like this if there were any basis to it, which there's not, but these people cannot do that. Mr. McGrain was part of this team, and let me just be very clear. At the beginning, go back to 2010 in time. Everybody's on the same side, okay? The Board of FAMRI, they want to do what's best for the flight attendants. Stanley and Susan Rosenblatt, they represented the class. They want to do what's best for them. Miles McGrain represented a group of these individuals. These two gentlemen represented some more. Mr. Weinstein, Mr. Page, Mr. Tropp, Mr. Grover, they all represented. All of them wanted what's best for the flight attendants. And so, as they only brought 10 cases to trial out of 3,000. There's 60,000 class members, 3,000 filed lawsuits. That's in the record. It's very clear. Of those 3,000 in 10 years, they only brought 10 to suit, 11. They won one, got $500,000. But it was hard. It was hard, and they wanted to come up with ways. Was there some way that FAMRI can use some of this money to help? The FAMRI board members, Young and Blessard, they wanted to help. These lawyers said, hey, can you get FAMRI to advance the costs for our experts? Or can we run our experts through FAMRI so they get better credentials?
I mean, experts so that the
Experts for the
lawsuit
individual
had a
lawsuits.
greater chance of being successful.
Right. So there were all these things that FAMRI might be able to do that would help all these flight attendants. Everybody here wanted to help these flight attendants. They all wanted to do that. So what did they do? They all got together and said, well, how can we do it? We have some restrictions. We have the settlement agreement, which places restrictions on us, and we're a nonprofit tax organization, and that prohibits us from funding litigation, from doing things. I mean, they say they're now faulting FAMRI for not developing science the way they need it. That's tobacco playbook. You develop science the way it develops, not the way you want it to develop. But at any rate, everybody, Mr. McGrain, everybody else wanted to come up with a way to do this. And we brought in the tax lawyers, and everybody met and explained to Ms. Blessard and Ms. Young and the rest of the board and these gentlemen and everybody that the law simply does not allow that. We can't do that. If we do that, what's going to happen is you're not going to get that money. FAMRI will be dissolved, and the money will go back to the tobacco companies, or the state will make it go to charity or something else. It's never going to go to them. So that's why when all that became clear, Mr. McGrain told them, before this lawsuit was filed, this is all in the record, he filed a detailed affidavit. Mr. Weinstein moved to intervene on behalf of his hundreds of clients saying the same thing. Yes, we wanted to do this, but we couldn't. And now we see if we do it, it's going to undermine the interest of all of our clients. Mr. McGrain also explained in great detail, confirmed what Blessard and Young said, which was, these gentlemen did represent me. Even if they didn't file a lawsuit on behalf, Mr. Hunter did on behalf of Ms. Blessard, but even as to Mr. Gerson for both of them, and for Mr. Gerson as to Ms. Blessard, they all represented us because we met regularly, talked about the cases. They asked for our help in these cases, and we were helping them, and we told them we can't do what they're saying, and they're now suing us for. So that was confidential information. These lawyers have confirmed it.
Confidential information, not about how do you win against a tobacco company for secondhand smoke, but confidential information about the workings of FAMRI.
Well, it's hand in hand. It's how can FAMRI help the individual litigation.
And you're saying during that time that they were representing Ms. Blessard, or one was, right, that she was on the board, and those were the confidences that were shared.
That's right. That's right. You know, and they're trying to distance these, saying there's no relationship between these lawsuits and this petition. You don't have to get there. These are current conflicts. That only applies if they're allowed to dump their clients. But even if they're allowed to dump their clients, this notion that they're unrelated is just absurd. Look at the petition that they filed, pages 8 and 9 explain about these lawsuits and say the reason we're bringing these petitions is because we tried these lawsuits and we haven't been able to, and FAMRI hasn't helped us. That's the basis for their communications with Young and Blessard. They were trying to help. Everybody was on the same team until it became apparent this can't be done, and these people pushed it anyway. Yes, they had some other lawyers that helped them initially. They were disqualified. Those lawyers haven't challenged the disqualification. They recognized the impropriety here. They're not here arguing any of this. None of these clients. This idea that we heard a representation that all their clients, 200, all of them approve this. That's not true. Only a small number, there's several hundred, but signed these engagement agreements, these solicitation letters, but the solicitation letters were full of lies. The solicitation letter says this team of lawyers, Mr. McGrain, Mr. Weinstein, Mr. Tropp, Mr. Page, our team has reached a consensus that we have to file this petition, and we want you to authorize this petition. That was a lie. They're the only ones who wanted to file the petition. The rest of the team says you can't do this. Don't do this. This hurts your clients. They weren't seeking authorization to file a petition. They already filed the petition. They're asking for it to be filed. They say other crazy things in there, like the family can't meet the settlement can't be, its objectives can't be met now because there's been a ban on smoking on flights. They put that in the letter. The settlement agreement required the ban on flights. It required the tobacco companies to join with us in lobbying Congress to remove that. So that was the purpose of the settlement agreement. To say that that was defeated by it, that's crazy. They did use the information that they gathered. It's right here in this petition. They used the information that family refuses to provide funding. That was confidential information that was given. It shouldn't be all out in the open. Yes, their letters are confidential to their clients, but they sent them to their clients. They sent them to Lonnie Blissard, was their client. She's on the board. She gave them to us. She attached it to her affidavit. That's how they saw we saw it. And as soon as they saw she had given them up, they dropped her. Mr. Gerson said, well, I didn't represent any of these people. Well, look at Miss Spurgeon. She's in the record. She filed something in this case saying she absolutely objected, and he says he didn't represent her, even though he filed her lawsuit. He filed a lawsuit that said Phil Gerson, attorney for Miss Spurgeon, and he's telling you he never represented her because he just did that as an accommodation because the statute of limitations was about to apply. He says he didn't represent people. He said, oh, I only had casual conversations at family events. That's a lie. That's a lie. The trial court found that was a lie. The trial court, to the extent his affidavit said what he's saying now, the trial court had affidavits from these other lawyers and the clients that said, no, it was a lot more than that. We talked about all of these things. The trial court,
no one found anything, I mean, because you got competing affidavits.
We did have findings. The trial court said, do you want to put on evidence? They said no. He said, okay, I'm going to resolve it based on the papers, gave everybody the opportunity, and he found that they currently represent these people. So when he's saying, I don't represent them and I never gave confidential information, everybody else says, yes, he did. And the trial court said, yes, you do. That's a finding. And there's no basis on cert review to find that that was improper.
If you could sum up pretty quickly.
Certainly. I think that the court fully understands these issues. I think that this case presents the court with an important opportunity, aside from the improprieties in this case, for the whole Florida bar to address this idea. We've provided a lot of cases in our brief from other courts, other jurisdictions, that say a lawyer can't drop his clients like hot potatoes to avoid the current client conflict.
Do you think that hasn't been clear in this state?
The third district didn't think so. We argued it till we were red in the face. We gave them, there's no Florida opinion that says that. There's federal opinions from all over. It would seem to be, there's federal district courts in Florida that have said that. It would seem to be obvious, but I think that the bar could use a reminder.
Thank you for your arguments.
Thank you.
The next case for the day is Peterson versus State of Florida. May proceed when ready, counsel.
Thank you. May it please the court, my name is David Hendry, and I, along with James Driscoll, we're from CCRC Middle Region. We represent the appellant petitioner in this matter, Charles Peterson. And I would like to first start by saying that we can have, when you have a biased juror serve on a capital case, we can't have confidence in the outcome of that case. In this particular case, we have not just one biased juror, but we have 5 biased jurors who actually sat on this jury.
But let me, on this, okay, so you're going to whether there's bias. Does there first have to be deficiency? In other words, this lawyer, there was an evidentiary hearing, and the lawyer explained why he kept these jurors on the jury. Now, you're saying that was unreasonable, but that's not what the trial court found.
Well, Your Honor, there's a parallel here because we have to look at 2 things. We have to look at these jurors' responses, and because we're in post-conviction, we do have to also look at trial counsel's explanations as to why these jurors sat.
Was that raised? So you're saying they should have been stricken for cause?
Yes, Your Honor.
So is that also a habeas issue that the lawyer was on appeal, was not competent because that lawyer didn't raise the issue on appeal?
No, Your Honor. The issues here between these 5 jurors, there was no move made to excuse these jurors for cause. So there being no move to strike the jurors.
So what you're saying is all you have to do on post-conviction is you can demonstrate that there's a biased juror, then you're saying there must have been ineffective, deficient. In other words, what I'm concerned about is this is the first time I've seen so many juror issues being moved into post-conviction when we'd ordinarily be looking at this as a question as to whether there was a challenge raised and whether the judge properly denied a cause challenge, right?
Yes, Your Honor.
This one is, you're saying this lawyer so missed the boat that that it should have been obvious to everyone there that these were 5 biased jurors.
Yes, Your Honor. So because
however many.
At least 5, Your Honor. There was no move made whatsoever.
Okay, so 5 of the 12 you're saying were biased that sat on this jury.
Yes, Your Honor. Now, what I want to, because I filed just 2 weeks ago, Matarans was released by this court, and I filed that as a notice of supplemental authority. And what I want to talk about is, first of all, we have to look at the jurors' responses.
Let me just, before you get into that, I'm a little confused about what happened with juror Thomas Walbert.
I'm sorry?
Juror Thomas Walbert?
Oh, yes.
As to what happened with him. What was, if you can explain to me, what was his communication with the judge, and when did that happen?
Juror Walbert was perhaps the most troubling juror of these 5 because we have not just one instance of juror misconduct, but 2 instances of juror misconduct. Before the misconduct even occurred, he made some very questionable comments which would cause one to really question whether he can be fair and impartial on this jury. So would Your Honor like to, you want to hear about
what
the
I want
misconduct?
to know, my understanding is that this particular juror had contact with the trial judge.
Yes, Your Honor.
Did that happen during the trial?
That happened, I believe, during voir dire.
During voir dire. Okay, I'll call that a trial. Now, this is where I'm confused. Did at some point in time the trial judge give counsel the option to excuse this juror?
Yes, Your Honor. It appeared that Judge Allen did, in fact, prompt the defense and almost invited them to say, what do you want to do with this juror?
Now, did that occur after the jury had been sworn, or was that during voir dire?
Both, Your Honor. The first instance of misconduct is when this juror sat down with Judge Peters and Judge Allen and said, can you believe all these jurors who say they're anti-death penalty? They obviously don't want to serve on this jury. That was. Can you
explain to me the dynamics of how that happened? Were they at the coffee shop, or he just came and sat with the judge? What happened?
Well, Your Honor, in Pinellas County, there's a big cafeteria downstairs, and it's a very busy place, and there's a huge line outside. So you have jurors, you have lawyers, you have judges, and so everyone is kind of mixed together. So it just seems very bizarre that you would have a juror going up to the actual trial judge who's presiding over the case to gossip about the responses that are being made by the panel. So Judge Allen, I think, was prompting the defense to let's get rid of this guy. Let's get rid of Walbolt, because he promised the court during voir dire before this discussion, he promised them, I'm not going to use any special knowledge or experience that I have because I have a brother who's got a jury trial consultant.
Did Judge Allen come back after that contact with the juror at the coffee shop? Mm-hmm. Did he come back into court during voir dire and inform everyone that that had happened?
Absolutely.
And was it at that point in time that the judge suggested that perhaps they should excuse this juror?
It sure seemed to be an invitation to strike that juror. The move was not made. So our argument here is that at that point in time, based on his prior responses which showed bias, then at least because of the first instance of juror misconduct, that juror needs to go. The second instance of juror misconduct is the most troubling aspect of this entire case in a single bullet death penalty case. Walbolt was overheard, this time by the clerk in that very court, discussing first-degree murder jury instructions, felony murder jury instructions with this panel. Apparently there was a nurse, and Walbolt said to her, I haven't heard about this case in the media. Apparently this nurse juror was questioning, why would this be a death penalty case? And he said, no, you're going to hear that there's two ways to prove first-degree murder. Now, if you look at the exact statement that Walbolt said to the court, because the court questioned him, she said, here we go again with this juror. What was said? And he said, oh, no, Judge, I wasn't talking about this case. I was just talking about first-degree murder in general. He's basically instructing these jurors as to the law. There's some doubt being expressed by the jurors as to why is this a death penalty case. He's forming this group of jurors here that you're going to hear about felony murder. He said, we heard about felony murder, but there were no felony murder jury instructions prior to this lunchtime discussion. Now, he promised the court that because he's got family, he's actually got Sylvia Walbolt, I believe it's Sylvia Walbolt. He said, this is my sister-in-law, and she actually writes jury instructions here in the state of Florida. So when we have case law, the case that I cited was a juror went into the jury deliberation room with an iPhone, and he looked up the definition of prudent. That case was reversed because the only place that you can get jury instructions is from the court.
And was that direct appeal or post-conviction?
That was a direct appeal
All right,
case.
and so let's go back. The issue, that's what I asked you. Okay, so as you've now pointed out, all of this occurred before the judge, as far as Mr. Walbolt, before the defense lawyer. So the question is, you're saying he was deficient in not striking juror Walbolt.
Absolutely.
Correct? Now, what is his explanation for why, even though he knew all of this, that he didn't want to strike juror Walbolt?
Yes, Your Honor. During his direct examination, when I was examining Richard Watts, who has at least 7 death cases before this, on death row, he told me, I don't remember having any specific discussions with my co-counsel about this particular juror and about why we would want to keep him. So, as I said, there's a parallel between initial responses of jurors and the initial responses of trial counsel when he's asked about any alleged strategy, any strategy that might have taken place when he's analyzing this juror. So, as this court said in Materans 2 weeks ago, and I'm going to say this, that we need to look at the initial responses of this trial counsel as to his explanations. He told us with regards to these 5 jurors, he said, I don't remember any specific strategic decisions that we had with regards to keeping these jurors. Now, I will concede that on cross-examination, he came to find, and I think what we were dealing with there is post hoc rationalization as to why he might have keeping these jurors.
Here's my problem. If this juror had committed such egregious misconduct, which you're alleging that the juror did, doesn't the judge then independently have some obligation to ensure that that juror doesn't sit? I mean, for example, say it's a juror that has expressed openly racial bias.
Yes.
And the defense lawyer is asleep at the switch or something. Where is the trial? Because again, what we're doing here, and is moving into post-conviction, something that should be in direct appeal, and that is why in Caratelli we try to move the bar to make it very difficult for there to be post-conviction relief for something that should be a direct trial issue. And so help me with that as to, again, this idea that if the trial lawyer several years later can't say, well, and he's apparently an experienced death penalty lawyer, maybe from what you just said, decides that I want that juror on, isn't there some presumption that that is reasonable, that the lawyer made that decision, and that, again, what you're saying is not just one biased juror, this guy missed the boat on 5 of the 12, and that's sort of, geez, this guy must be the worst lawyer in Pinellas County.
Well, Your Honor,
state.
This court kind of recently came out with the case of Robards, which is another case from Richard Watts. And that's a direct appeal case. And on direct appeal, it was kind of unusual for this court to engage in a very extensive discussion as to the possibility of ineffective assistance of counsel. And as this court has done many, many times, this is a direct appeal case.
Okay, so you've spent a lot of time on this one issue, but if this guy is so incompetent that he is asleep at the switch throughout, what is your other than the jury issue? What other deficiencies are glaring to show that, like someone says, well, he didn't object to that one question, or he didn't object to that closing argument, it's kind of picked apart. But I like to see it in what's the whole view? Is this a guy that didn't investigate? Is this a guy that didn't present mitigation? Is this, or a woman, what's the whole picture to show that probably he was just sleeping through this trial? And I know that's not the standard, but you don't understand what I'm saying, that you just can't pick this part or that part and just say you get another trial.
Yes, Your Honor. There's 2 other instances of IAC that I would like to talk about. And I think the first one that I should talk about, because this happened very much so in voir dire again.
I'd like to ask you a question about Mr. Walbolt before you go on to these other issues. What shows that he was actually biased? Because that's what you've got to show. You've got to show that it's apparent on the face of the record, or plain on the face of the record, that he was actually biased. Now, I think you can show plainly on the face of the record that he was actually loquacious, but I don't see what demonstrates the bias. Please identify that for me.
Yes, Your Honor. He said that he had been robbed before. He said that his wife was actually robbed twice. He couldn't believe that the whole...
So anybody, so there's a presumption of bias that anyone who has been a victim of a crime will be disqualified from serving as a juror. Is that your position?
That's not my position, Your Honor, but looking back at the Materans case, that juror was basically, I'll call him a burglary hater, a burglar hater. Walbolt here is a person who's been robbed. His wife has been robbed twice before. We're dealing with a robbery of a Big Lots. So, and it's not limited to that as well. He said that he works very closely with law enforcement. He mentioned CPD and SO. We know those are the acronyms for the law enforcement agencies. The jury trial consultants, the real problem here is that he said, I have specialized knowledge about jury instructions and jury trials and stuff, but he said, he promised, I'm not going to use that here in this case. He did that in the cafeteria. We have the misconduct there, and the bias shows that if he and the trial judge said, plops himself down in front of these 2 judges, and he says, can you believe that these people are saying they're anti-death penalty? What that indicates right there is that he is a pro-death penalty person, and he's not going to believe anyone who says they're anti-death penalty.
Well, now didn't the trial counsel say that his overarching concern in picking the jurors was the penalty phase, in terms of a death case and where they stood on the death penalty. Now, Mr. Warbaugh said that he was pro-death, but only in the event that you killed a correction officer. And didn't that mean that anybody else, that he was sort of biased toward the defendant?
Well,
Since he didn't kill a correction officer?
There were some discussions about whether someone might be, really requiring a great bar before they could impose the death penalty. But, Your Honor, I want to go back to, and I will concede that there were some comments made from these particular jurors about, perhaps not being so pro-death. But these jurors also could have been tainted by Walbolt. Going back to Pariente, this is a perfect segue, Your Honor, because the state engaged in horrible misconduct as they were singling out all these jurors. Any juror who expressed any kind of apprehension as to whether or not they might impose the death sentence, the prosecutor said, look, this is the law, and the legislature has mandated that this is the law. So this goes into issue 2, because if these jurors might have expressed maybe not they're not going to impose the death penalty, the state then made sure to prejudice them and make it seem like in violation of Farrell and Brooks that death is mandated in this case. The state actually used that word, mandated, in several instances.
But then what the state, if you read that in context, isn't what the state saying there is that the state has mandated the factors that you got to consider. Because right after the word mandate is used, it makes a reference to the jury's determination. So I don't see how in that context there, that is an indication that the prosecutor is saying you must give the death penalty in this case. Why am I wrong about that?
Well, Your Honor, looking at the transcript, first he said, the legislature on your behalf has decided that is the circumstances in which a person could be put to death. Could you sign that verdict form? So he's basically saying, if you're going to sit on this jury, you need to tell me you're going to sign that verdict for death. This juror, Stevens, said...
That's not what Brooks involved at all.
Brooks
or Urban, and it was the same prosecutor in those cases. That wasn't even close to what you just read.
Well, Your Honor, there's more egregious examples.
Okay.
With juror Stevens, she said, absolutely, absolutely. She actually went so far to say, I'm a very law-abiding citizen. So these jurors were kind of instructed that if they're going to come here with the inclination to vote for life, then they're biased and they shouldn't be sitting on this jury. Quote, this is in front of Dickerson, in the state of Florida, the legislature has indicated that under certain circumstances, death is the appropriate punishment. With Juror Bertel, they said, you indicated that you would have to look at things and feel whether or not it's appropriate. And we've had discussions about how the legislature has kind of taken that out of your hands a bit. Would you follow the law? And the juror answered yes. So with Bertel, this is a juror who said, I'm going to kind of weigh things. I'm going to look.
Well, each time that somebody touches on that subject doesn't mean that it's an Urban or other case violation. Brooks, because that the legislature has established this weighing, and it's a very difficult subject to discuss with lay people, and just the fact that it's discussed doesn't seem to me, does it, that it automatically flips over into improper discussion?
Well, Your Honor, there are so many instances, and again, this is a single bullet death penalty case, and there were so many instances of examples of the state attorney addressing these jurors in front of the whole jury panel, talking about, actually using the word mandated. So, if it was just an isolated statement.
Well, the question is in context as to what the legislature requires. But, when you try to stretch, I think it weakens your arguments on other points when you try to stretch some of these statements into a Brooks or Urban, which were the most inflammatory statements that you can find. These aren't even close to that.
Well, Your Honor, I'll stick by my arguments in my brief, and I'll stick by what the transcript said. And just to address the second portion of the IAC that I'd like to talk to this court about is the IAC for failure to consult an expert in eyewitness identification. And when you talk about asleep at the switch, this is an attorney who repeatedly talked about books on his bookshelf that dealt with eyewitness identification. The problem is the books on his bookshelf are not evidence. The jury doesn't know about these books on his bookshelf.
Have eyewitness identification experts been allowed to testify in court?
Yes, they have, Your Honor. Dr. Brigham detailed his experience. He was available as early as 1980. Long history of research.
What would the experts say? That the witness in the position he or she may have been in could not have seen what she saw or he saw?
Yes, Your Honor. We consulted Dr. Brigham, and Dr. Brigham testified extensively, and his findings are all detailed in the briefs starting at page 58. I want to talk about the Simmons case because there were several concurring opinions. I'm sorry.
Expert is reversible error.
I don't believe so. I'm sure I would have cited a case.
Yeah, we've actually said the reverse, which is that when the judge didn't allow an eyewitness identification expert, that it was not abuse of discretion. I think I disagreed with that, but with this extensive testimony of Dr. Brigham, did he actually impeach the eyewitness identification of the particular individuals that identified the...
Absolutely, Your Honor. I mean, this was a mass perpetrator, and this involved cross-racial identification.
So he said those were unreliable identifications.
Oh, absolutely. The presence of a gun, the stress, there's a dead body there on the floor.
But did counsel touch on all of those topics during this cross-examination of the eyewitnesses in terms of vetting whether or not their testimony was credible in terms of the opportunity to see and cross-racial and stress and all of those?
I understand what you're saying, Your Honor. He did touch, but this is a capital case and death is different, and they should have consulted Dr. Jack Brigham, and I will say, based on reading of Simmons...
Didn't he say he read this book by this woman who thesis was Elizabeth Loftus was essentially the same as Dr. Brigham?
Your Honor, there is no substitute for Dr. Brigham's testimony.
Well, I might agree with you that I think we should come to a time where we do allow experts, but the time has not, it hasn't come, and so now we're going to say that somebody was deficient how many years ago in not hiring an expert that more likely than not would have been disallowed by the trial court. So that's my problem with that issue, about this is such an egregious deficiency.
Your Honor, we would just say that what we have seen in the case law is perhaps an evolving standard of decency and the assessment of the admissibility of this type of testimony. For a third example, I'll just mention is that the Williams rule evidence, there was repeated comments, there was repeated testimony from trial counsel about he had a strategy not to challenge the Williams rule evidence. We'll say there's deficient performance here all across the record globally.
Your time has expired. I'll give you an additional minute for rebuttal.
Thank you.
May it please this honorable court. Your Honors, my name is Catherine Blanco with the Attorney General's Office on behalf of the state of Florida. Before I begin my argument, there is one misstatement, I believe, well, there are a couple of them, but one that I would like to point out at the very beginning of my argument, and that has to do with the inquiry Justice Labarga made about the lunchtime contact with the trial court. As the trial court, which is Judge Linda Allen, as she described it, she was sitting in the lunchroom at a table with Judge Peters. At that particular point in time is when the prospective juror Walbolt sat down talking to Judge Peters. Apparently they had gone to high school together. There was an upcoming reunion. And so there was a discussion, and there was a reason for him to have made contact with this individual. And he did sit down. At that point in time, Judge Allen realized it was one of her jurors, and she got up and left. And so, and the comment that was made by Walbolt was that he couldn't believe there were so many jurors, opposed to the death penalty, which was in a way similar to what some of the comments that were made at the bench. Everybody wants to get off this jury. We've never seen so many people that are looking to get off a jury with a 2-week trial. And so that first comment was prospective juror Walbolt's comment toward Judge Peters, who was sitting at the table. Trial court Judge Allen tells the parties about it, brings Mr. Walbolt in, swears him in, inquires about the contact, and the request of the defense at that point in time is instruct him not to have any conversations about this case, about any case. Do you understand? He agreed that he understood. He did not consider it to be a comment on what was happening, particularly with respect to the facts of this case, only that it seemed like a large majority of the panel were against the death penalty.
Well,
so you
about,
have that.
Yes. that comment is a little bit troubling, but what about the whole notion that Mr. Walbolt was instructing the other jurors about first-degree murder? I mean, we all know that it's the trial judge who instructs the jury on, the crimes that are alleged. And so how are we supposed to treat the notion that Mr. Walbolt is going to educate the jurors about what is first-degree murder?
Justice Quince, the state disputes that there was an instruction to the other jurors about the categories, and the trial court, the post-conviction court, disputes the defense characterization that Mr. Walbolt was instructing the jurors. The second contact that you're discussing...
There are two ways that you could commit first-degree murder.
The discussion was that the defense attorneys and the state had both discussed, although there had been no jury instructions, the defense attorneys and the state had both discussed with the jurors that there were two types of first-degree murder, premeditated and felony murder. A general discussion on this, and there was one nurse, prospective juror, that Mr. Walbolt was talking to. And they brought him back in. The clerk was the one that said, we have another conversation by Mr. Walbolt, bring him back in. So they bring Mr. Walbolt back in. He says, the court says, the court will instruct on the law. The jury has been told that they are going to receive instructions from the court on the law, that he didn't consider it a substantive discussion of the case because it had been what the defense attorneys and what the prosecutor had been talking about. The trial court at this point in time does indeed turn to the defense. What do you want to do? At that point in time, the defense says, re-instruct. They're not striking Walbolt. Okay, so they are keeping Walbolt. And as Justice Perry pointed out, what are Mr. Walbolt's views on the death penalty? He was of the view that he would not be in favor of the death penalty except in a case where it was an individual on death row that was accused of killing a corrections officer. So the overarching strategy is
Let me
just...
stop you for a second.
Let
me stop you for a second. And I could spend the rest of this week here telling you jury stories, just in my experience.
I'm sure, Your Honor.
All right, but and there's always one or two in every panel that can cause problems, and for some reason lawyers always want to keep those two. But let me ask you this. I mean, it seems to me, and this is why I'm having problems with it, that once trial counsel learn about these jurors' more or less leanings, and the judge that gives them the opportunity to strike them, I guess at that point in time they were going to plug in the alternate. Had the jury been sworn in at that point?
The jury had not been sworn. That was the second point I wanted
so-
to correct. The jury had not been sworn at the time of the second...
So we have a talkative juror who thinks he knows it all, who can taint the entire panel, and he's given the opportunity to get rid of this guy, and he doesn't take it. I mean, am I missing something?
And that's a matter of his trial strategy. It fit in with his trial strategy. Was it a reasonable decision to keep a juror on the panel that was very defense favorable, particularly for the penalty phase?
Well, the other part about it, and this is a friendly question, when I realized who the sister-in-law was, Sylvia Walbolt, who Watts knew was a lawyer who had some liberal views. In fact, Ms. Walbolt's firm represents death row individuals, and I would suspect that and I think Watts, by saying he knew who she who he was, would think that that would be helpful to him if the person was talkative, might be talkative in their favor. So that's, even though they said that Watts didn't remember why he didn't strike him, didn't he talk about knowing that, about Walbalt's relationship with Sylvia Walbalt?
Well, there was a discussion that of the identification of the best evidence and the sister-in-law on jury instructions. It was more general than that, but it was clear, to everyone that's in the Pinellas County and Hillsborough County what their discussion was. But I'd like to address the fact that he doesn't remember or might not remember on a particular point. That doesn't take away Strickland's
All right, so he
presumption.
didn't say anything about, I wanted to keep him on because of the relationship. That's not
to Sylvia Walbalt. What he did say was that he didn't recall all of the reasons, but we have in the record the contemporaneous decision when the trial court says, do you want, what do you want to do? Re-instruct him. So that is consistent, certainly, with the strategic decision.
And didn't he also discuss each and every juror's, whether he would preemptory challenge or challenge for cause, discuss it with the defendant, and did not defend it?
It was absolutely, Your Honor. It was reasonable to listen to the client and to make that strategic decision. It was an informed strategic decision as to what jurors to keep. Remember, you've got 3 days.
Let's assume it's deficient, okay? Let's assume that. But still, as Justice Kennedy asked, and our standard under Caratelli, is that an actually biased juror has to sit. This is a person that maybe people wouldn't want on a jury because he's too talkative or thinks he's a know-it-all, but does that, under our case law, does that make him actually biased?
No, not at all, Your Honor. There is no actual bias for any of these jurors.
Well, how do you
yes, Your Honor.
Well, how do you demonstrate actual bias? I mean, as I understand his argument, he's saying that it's demonstrated because he was a robbery victim. His wife was a robbery victim a couple of times, and I believe he said something else. But so, what do you show to show that a victim?
On this particular case, Your Honor, or in Caratelli, I mean, you have to show bias. In fact, bias against this defendant. The fact that you have, certainly, there is no per se cause challenge based upon individuals that are victims, and I understand very clearly that CCR would like to turn this into a direct appeal case. We are not here on direct appeal. We are here on a claim of ineffective assistance of trial counsel and under Caratelli.
Well, even
and
if,
so that's
so the issue is he may have been able to be stricken for cause.
No,
but let's say you concede
okay,
that, okay? He could have been stricken. Maybe he could have been stricken for cause. That's not, as I understand what we went to in Caratelli, it's not that he could have been stricken for cause. It has to be an actual bias. And I think there is, again, I can't call it up, but it's more than just that you were a victim of a crime.
Absolutely, Your Honor. And I believe former Justice Cantero authored the opinion, and I believe the decision was unanimous in Caratelli. You just can't say, okay, you may have had a cause challenge, and you didn't raise a cause challenge, the trial counsel didn't raise it, so he didn't ask for or use a peremptory and didn't forfeit peremptories and ask for additionals and had denied them. That would completely turn preservation of error on its head. And so and that's how this court at great length in Caratelli says you have to show actual bias, which is bias in fact. And what do you have? You have an individual who says he would treat all witnesses equally, so the discussion about law enforcement, on both sides, quite frankly, because both on having law enforcement and best evidence practice dealing with both criminal and civil practice, that he would not afford any special credibility to law enforcement officers to testify. He himself said that he had been arrested back in the 70s for trespass, and coming down so strongly with respect to his views on a death recommendation. Attorney Watt stated that he, on balance, would look for jurors who would be very receptive to a life recommendation in this case. And indeed, 4 of the jurors, the verdict, the recommendation was 8-4. And so you have a decision like that was made in Harvey and in Owen. And Owen is a case from this court that has been addressed by the 11th Circuit, of course. And we've cited in our brief in the discussions in Owen where you have a victim, a person that has been a victim of very serious crimes involved in there, and a discussion of why, on balance, trial counsel can make a reasonable strategic decision to not strike this particular juror. It fits in with their overarching strategy, the notion that the jurors could be fair and impartial, and indeed assured the parties, when questioned, that they could follow the law. Now, again, this morning, Mr. Hendry is trying to fit this into a direct appeal case, which, of course, this court is well aware it is not, and so we're looking strictly at the ineffective assistance of trial counsel claims. In this particular case, the post-conviction judge, who was the same judge that presided at the time of trial, conducted the evidentiary hearing in this case and made very specific factual findings, which are supported by substantial competent evidence in the record, and addressed each of the challenged jurors and explained why, heard discussion as to why there was no deficient performance and no resulting prejudice. Mr. Hendry has also made a comment this morning about the experience of Mr. Watts. Mr. Watts had over 25 years trying criminal cases. Mr. McDermott, who has since passed away, was unavailable for the evidentiary hearing, but he was primarily guilt-phase counsel. Mr. McDermott had over 45 years' experience. And the fact that Mr. Watts may have some clients that are on death row means that he is willing to take these most difficult cases, and they are scrutinized by this court, and they have those that have gone through post-conviction, and that the death penalty has been upheld on them against challenges to ineffective assistance of counsel means that this court has rejected his claims. So some sort of suggestion that may be made that he has some clients on death row, well, that's true. That's what happens when you take these most difficult cases, some with horrific facts, but rest assured, as this court knows much better than I could ever elaborate, how difficult these cases are and how much effort is put in.
I just want to make sure.
He was not asleep at the wheel.
On Caratelli, we define actual bias that the defendant must demonstrate the juror in question was not impartial, that the juror was biased against the defendant, and the evidence of bias must be plain on the face of the record.
And
that's
you do not.
That's the standard.
That's the standard, and you do not have that here, Your Honor. As Justice Kennedy noted, he was loquacious, but you have not established the actual bias. I will be happy to address the other jurors if you would like. If the court has any questions about the other jurors, I think certainly the trial court addressed them at length in her order.
During voir dire, did the defendant exercise? Did the defense lawyer exercise peremptory challenges?
Oh, yes, Your Honor. Over 50 cause challenges were granted. Both sides exercised a total of 21 peremptories. The defense had 10 peremptories they exercised, and were granted an additional peremptory that they exercised.
A lot of the cause challenges may have been because the person could not serve that for 2 weeks and not personal reasons, and
a lot of them were agreed to. Certainly, Your Honor. Certainly, and you had one of the cause challenges to an individual who was a psychic.
Something else that was raised. The whole notion of failure to make an opening statement. Are we referring to the sandwich type of thing, or?
No, the defense or CCR and post-conviction claimed that trial counsel was ineffective because they said they would reserve opening statements. And so you come on the heels of the prosecutor's opening, and they announced that they will reserve the opening statements. Mr. Watts is asked about this in post-conviction, and his response is, at that time, we wanted to reserve it. We didn't want to make an opening statement because one of the issues, as this court is well aware of, was their Williams Rule. And there were multiple Williams Rule cases that were eligible to be presented. At the pretrial hearing, there were actually 6, a maximum, or 6, and they involved cases beginning in February of 1997 through August of 1998. And so you have a possibility of 6 Williams Rule cases coming in. Now, the defense always knew that probably not all of them, the state wouldn't try and present all of them. You don't want it to become a feature of a trial. So they pulled in their evidence, and they did have some witness problems, especially with respect to one of them, the cases. So they weren't certain they were going to use all 6.
One of the Williams Rules cases that was presented, what did it involve the rape case?
One of them did involve a rape case, Your Honor. During the guilt phase, the evidence was sanitized. The victim in that case, and I'll refer to her as MP, she testified about a robbery, and the DNA evidence that came in by stipulation. And the stipulation read, during the course of the robbery, and the victim during the robbery. And so you have that written station, that in the record saying robbery.
The reason I asked that, going back to jury selection, there was a juror that was kept on the panel, Johnson, who apparently was raped when she was 16 years old. Yet counsel knew that he had been given notice of the potential of a Williams Rule case being presented where a rape was involved, and he kept her on the jury. That's of concern.
Sure, and I'll be happy to respond to that. This is, and again, I'll refer to it as Juror AJ. Juror AJ, when she was 16, testified that she had been the victim of a rape. The charge was against an individual by the name of Cedric Bailey. He was charged with unlawful sexual conduct against a woman or an individual above the age of 12. Apparently Bailey and AJ knew one another, that there was some working relationship, and it occurred over a course of time. Now, Juror AJ says she discloses this about the incident that happened when she was 16. By the time this trial is, she's now, I believe, 23 or 24 at the time of trial. She indicates that this had happened to her, and she was asked if her experience as being a victim would affect her ability to sit on a case, because she's got a case that's murder. Remember, they're keeping the rape out of the guilt phase. And so would this affect you? No, I can sit on it. She was unequivocal in that. Would you give law enforcement any special credibility or attach that to their testimony? In this particular case, she was somewhat dissatisfied that her attacker only got a 2-year sentence. So any resentment she might harbor arguably might be against the state, because she felt that he got too light of a sentence. And so you look at what happens in the guilt phase and then in the penalty phase. In the guilt phase, again, the case is sanitized to describe this as a robbery, repeatedly as a robbery. And I understand that the defense says, well, they must have assumed that it was a rape, but it's always referred to as the MP case and the robbery. When you get to penalty phase, then you have the defense having to deal with the fact that there are 13 prior violent felony convictions for this particular individual. He has 9 life sentences. So if they are saying somehow that that this individual who had assured everyone that she could follow the law, that the fact that she was a victim would have no effect on her determination, that she thought he should have gotten a harsher sentence, well, she gets into the penalty phase and learns that this defendant has 9 life sentences. Certainly that he has received harsh penalties for that. And so the trial court, the post-conviction court, in her order addresses very specifically the allegations that are raised. The last allegation as to Juror AJ, because I believe my time is running up, is that there was a booking photo that somehow this Cedric Bailey resembled the defendant. Well, the booking photo they introduced is from 2006. Our trial is 2005. So this booking photo is certainly not available to defense counsel. And also, when the state in post-conviction says, well, here's a photo of the guy that we're bringing in at the time, and the juror never says, this man on the stand resembles my perpetrator, well, that's because the argument was that he didn't. The defense never proved that there was a resemblance. There was quite a disparity in size and age, because the defendant is, I believe, 46 at the time of trial.
You're out of time.
Thank you. I appreciate Your Honor
Thank you.
allowing
Rebuttal,
me to go over
1 minute.
seconds. Thank you.
I'm just going to make 2 quick points. First about Walbolt, and then I want to talk about Tunsil. Walbolt, Mr. Watts was asked, do you have specific recollection of having discussions with Mr. McDermott talking about whether or not you should strike Walbolt? He said, I don't have a specific recollection. When read the discussion, the exact record discussion, He said he was actually quite surprised in reviewing these responses why he didn't at least ask for a curative instruction. Going to Nicole Tunsil, this was perhaps the most troubling juror. She served as foreperson on this jury. She could not respect, she could not follow the law on the right to remain silent and the presumption of innocence based on this response. She said, I want to hear from Mr. Peterson. And then the court actually had to interject and say, you know, this is the law. We have a presumption of innocence and a right to remain silent. This is what she said. I'm totally clear on what the judge read. I think I've watched enough Judge Judy and things like that to understand it's the state's responsibility to provide us with the burden of proof. But just as a human being, I would like to hear what Mr. Peterson has to say. But I just think at some point I would like to hear. And if he chooses not to, then so be it. But I feel like the gentleman in front of me, the one who harbored presumption of guilt, if your life was on the line, wouldn't you want to get up if he doesn't say anything but, look, Nicole, I'm not guilty. I think I'd be at peace with it. That statement right there shows she understands the law and presumption of innocence, but she's going to presume him to be guilty.
The thing is, I mean, I went through that every day of my life on trial bench. Everybody comes in with that attitude. And once judges explain to them what the law is, then they'll say, I accept the law. If that's what the law says, that they don't have to testify, I'll respect that. But most people come in with that attitude and they want to hear from the defendant because they don't know yet what the law is.
Our position is, if you read Ms. Tunsil's response, she said she was going to disregard the law and she would still require him to testify. She even went to the press after verdict and said it might have been different had the defendant got up and testified. I'm out of time, but I will just conclude with saying that Mr. Peterson was denied his right to a fair and impartial jury and effective counsel. Thank you very much.
Thank you for your arguments. Court is in recess for 10 minutes.
All rise. All rise. Supreme Court of Florida is now in session. Please be seated.
Our last case for the day is Delgado versus State of Florida. You may proceed.
May it please the court, I'm Steve Bulletin from the Public Defender's Office in Bartow. I represent the appellant Humberto Delgado. Florida's long-established proportionality standard says that the death penalty can be affirmed only if this court finds that the case before it is both among the most aggravated and the least mitigated of first-degree murders. Humberto Delgado's case satisfies neither prong of that test. Remarkably, in this case, with 8 doctors expressing their diagnoses and their assessments, with lay testimony from numerous witnesses who knew Humberto Delgado in the Virgin Islands, in North Carolina, and in Florida, these facts were established by overwhelming and, with one partial exception, uncontradicted evidence.
Well, we've got apparently, as you say, this is about, in terms of consistent testimony, including from the doctors, a very seriously mentally ill individual. And apparently the judge didn't contest that. It was presented. But then there has been something, does it have to be both the most mitigated, least aggravated? But isn't this an aggravated case? It involves a law enforcement officer, it involves another aggravated assault. So how do we balance that, because we haven't gotten to the point where mentally ill individuals are exempt from the death penalty. How do you square that?
There's a couple things I need to say in response to that. First of all, having seen the tape of the oral argument last June in the Thomas McCoy case, I want to make it very, very clear that I'm not arguing that the Eighth Amendment precludes the death penalty for mentally ill individuals. That's an evolving area of law for another day, probably for another court, whether it's going to go the same way as under 18, whether it's going to go the same way as mentally retarded, it may, but that's not what I'm arguing. What I'm arguing is under traditional proportionality analysis, and that's in answer to your other question. The court has made it very clear in Cook, in Cooper, in Almeida, in Green, that both prongs of the test have to be satisfied. It has to be both among the most aggravated and least mitigated. The state, in their answer brief, turned that on their heads and said, well, this case isn't among the least aggravated or the most mitigated. Well, actually, it is among the most mitigated that this court has seen, particularly in the area of mental mitigation. On aggravated, no, it's not among the least aggravated, but it's also not among the most aggravated. When you say it's an aggravated case, there are two aggravators in this case. Now, there have been many proportionalities with 2 and 3 aggravators and even more. This case does not have hack. This case does not have CCP. This case does not have a true prior violent felony. In fact, he's got no significant criminal history at all for 34 years.
Have we ever said that the killing of a law enforcement officer is a significant aggravator, isn't it?
I'm not saying it's not significant. Of course it's significant, and it was given great weight, but it's not dispositive. This court said in Wheeler that death is not necessary or automatic for a killing of a law enforcement officer.
Well, of course, there is no automatic death penalty. There can't be under the law. But explain, and I think this is what, because I do consider, murder of a law enforcement officer, I pick that above CCP. I mean, just if I'm going to pick we cannot tolerate in this society. But what does the record show? What was the evidence about that he was under extreme emotional distress at the time of the murder? Could you factually explain what we know about how this murder occurred?
Okay, well, about what we know, are you talking about the actual events that occurred on the day? Yes. And I won't at this point get into the mental illness that he has.
Because do you appreciate that someone could be very seriously mentally ill, but they could act in a way on the day of a murder in a very deliberate way?
I do understand that, but this is a case where I need to say that there have been a couple of cases of law enforcement officer murders that were reversed on proportionality. There's Hardy and there's Fitzpatrick. Hardy is slightly more less aggravated in this case, only because of that moderate weight second aggravator of momentarily pointing but not firing a gun at Sergeant Mumford, and I want to get into that in more detail later if I can. But this case is way more mitigated than Hardy. The other case, Fitzpatrick has enormous mitigation, but 5 aggravators.
Okay, I'm asking you about what happened.
Circumstances leading up to, the judge found as a non-statutory mitigator the enormous stress that he was under during the weeks and the days leading up to the crime. He had been kicked out of his residence in North Carolina by the mother of his child, who loves him, because she couldn't deal with his mental illness anymore. He was just acting too crazy, too impossible to deal with. He's allowed to stay in Oldsmar with his aunt and his uncle. And the testimony from the aunt and the uncle is that he's walking up and down, pacing constantly, sleep deprived, not eating. He's scaring their children, not through any threats or violence or anything like that, but just through his weird behavior. He's talking to himself as if he was talking to somebody else. He's, I'm talking about people out to get him, and there's other evidence of that as well. People who have called him on the phone, talked to him. His girlfriend in North Carolina called him on the phone and talked to him, and he was acting the way she's seen before when he's sleep deprived and not eating. He was decompensating. He was off his meds. Eventually, his aunt says to the uncle, he's got to go. He's scaring my kids. He's too crazy. He's sick, and I got to get him out of my house. So they tell him, well, you got to leave. They told him he could have an extra month, I believe, but he was offended, and he left, and he was kind of staying with people, and he was on the streets.
And how long ago was this in relationship to the murder?
A week or two. He's staying with some people. He's not staying, her grandmother comes back. He has to leave. He's sleeping on the streets. He's sleeping in his storage bin. He's been going to Bay.
What do you say? Wait, he's sleeping in a storage bin.
He's like a storage facility, which is where he retrieved all of his earthly goods and put them in the bag when he goes on this 15-mile trek. The morning of the crime, he gets all his stuff and he puts it in a large bag, like a canvas bag, and he starts walking, vaguely looking for the VA in Tampa, which he doesn't exactly know where it is, but he's kind of got some kind of general idea. Now, this guy has got severe physical problems documented, bad knees, bad back, neck, whatever. He's walking in the heat and the rain with this pack. And he's got in the pack, and he shouldn't have, he's got 4 firearms in the pack.
Can we just put a little pin right there? Where in relationship to this walking to Tampa, I thought on the same day he also tried to retrieve money that he had put on a layaway or something to that effect? Did that happen before or after the trip
toward
to
the
Tampa?
Toward the beginning of the trip, he goes into the store and he wants
While
to
he's
take.
still
He wants to
in
get his
Pinellas.
money, but he wants to take the watch off layaway. And the woman tells him, "We can't give you any money because we just opened. We don't have money in the till right now." He says he'll wait, but then ultimately, I guess 45 minutes or something passes, and he says, "That's okay, I'm leaving," and he starts on his trek. Now, he's got 4 loaded firearms and a laptop computer, which he owns. Basically, it's in this homeless bag that he's got. He's taking everything with him. He's going to the VA. He's not committing crimes. He's not like going somewhere using these firearms to rob a bank or rob it. He's taking them to the VA. There's a little bit of history on that because
Because you're going to run it. I want to go, we fast forward to, at some point he acquires a shopping cart.
Right. 15 miles later, many hours later.
He's walked, he's got it, so he puts his stuff in the shopping cart.
He's got his stuff in the shopping cart.
He's going along to try to find the VA in Tampa.
Yeah.
That's, okay. And that's in the record. Now, what happens with the police officer and the tasing, and that's what I'm trying to...
That gets a little sketchy. I'll explain it as best I can.
Well, that's what I want to understand the facts.
I'll explain it as best I can. Here's why it's sketchy. It's sketchy because there's a camera in Corporal Roberts' car, but it's not activated. There's no information about Delgado on the police car computer. Corporal Roberts obviously cannot testify. Delgado doesn't testify. And when he talks to like the various psychiatrists, psychologists in this case, he had like snapshot memories. He wasn't really able to give a coherent account. So we don't know exactly what
I thought
occurred.
there were several eyewitnesses that talked about this encounter.
There were several partial eyewitnesses, but the state has an eyewitness by the name of Richard Farmer, who's a 7-time convicted felon. He sees Delgado get tased. He sees, and there's conflicting evidence on this, but the state's witness, Richard Farmer, says Delgado pulled the taser out of his shoulder.
Well, so do we know what led to the police officer tasing Mr. Delgado?
We can conjecture to a degree.
Well, we can't conjecture here.
Well, you got to conjecture because there's no testimony on it.
Well, we've got to use facts, though. What did the trial court? Did the trial court find anything on this?
I don't recall if the trial court found anything on it or not, but what you get, apparently, Corporal Roberts stopped Delgado, starts going through his things, finds the laptop, says things to the, implying that I don't believe this is yours. may or may not have seen a gun. I don't think that's completely clear. At some point, Delgado bolts, starts to run. Doesn't attack Corporal Roberts, doesn't try to pull any of the weapons or anything. He runs. He gets tased. Where he gets tased is not completely clear. According to Richard Farmer, he pulls the taser out of his shoulder. The taser wires are found in his dreadlocks. There's a witness in a car who hears the taser. Dr. Taylor, when he's testifying for the state in the guilt phase, says he wouldn't be at all surprised if Delgado was momentarily stunned by the taser. After he gets tased, a fight occurs between Delgado and Corporal Roberts. Farmer thought the homeless guy was getting the better of the fight. There's another witness named Kent Sharp who thought that the officer was getting the better of the fight. At some point, the officer gets shot. Now, Richard Farmer, the state's witness, the 7-time convicted felon who was drinking and wanted a reward, he says that he saw the homeless guy standing over the officer, reaches down, point blank, fires a shot into his chest. We know from the evidence that's not true because the medical examiner testified that the officer was on his back, the shot entered his arm, went into the humerus, fractured the humerus bone, then apparently came out of the arm and went into the chest cavity. So we know that Farmer's certainly not right about what he says he saw there. So, I mean, basically that's what we know about the altercation itself. We know that the jury had the option of a verdict. They had a verdict option of premeditated and felony
Well, we have
murder,
the judge
both.
finding that he was found that he was under the influence of extreme mental or emotional disturbance at the time he killed Corporal Roberts and accords this mitigating factor substantial weight.
Yes.
You got that?
Yes.
Well, since you're giving us the scenario of what happened, you know, the other aggravating circumstance here is that there was an aggravated assault on another officer, correct?
There was,
So tell us how that aggravated assault occurred.
Okay, well, I mean, again, how that occurred was that Corporal Roberts' supervisor, Sergeant Mumford, gets the radio call, officer down, responds to the area, sees Corporal Roberts on the ground, sees a disheveled-looking guy that initially he thinks is coming to help, and then he decides, no, this is probably a suspect. The homeless-looking guy is running. He reaches into a bag and points a firearm at Mumford. The whole thing, according to Mumford, took a matter of seconds. And
But did not shoot. He
did not
simply
shoot, which is, and again, I want to contrast that McCoy case that you all heard 3 months ago, which is a case where the guy went to Tampa and 11 days later said he was going to go out in a ball of flames and started firing at officers. A little bit of a different situation there. Also, that one was given great weight. This one was given moderate weight. You know, when you're assessing for proportionality purposes prior violent felony.
Well, what
you have
happened
to
after
look
he takes the stand and he points the gun? Then what happened?
Well, actually, I wanted to get to that too because he points the gun, or according to Mumford, he points the gun. Mumford then kind of gets to the side of a building and draws his own gun. Delgado flees. Mumford makes a radio call in which he says, the suspect is heading west on Arctic, and I think he's 10-0, meaning armed. I think he's 10-0. Mumford didn't report that he pulled a gun on me, he pointed it at me. Mumford didn't say he's 10-0, even though Mumford testified he still had the gun when he ran away, when he saw him running away. Additionally, there was conflicting testimony from Mumford. He testified that he didn't draw his gun until after Delgado drew his gun. But on the night of the incident, Mumford had told police detectives that he had his gun drawn as soon as he got out of his car. So there's conflicting testimony on that. And I have trouble wrapping my mind around the concept that you wouldn't have your gun drawn if you're at the scene where an officer is down and is lying on the ground.
Well, okay, that's, again, you said
that's credibility, I understand.
He drew the gun. It was an aggravated assault. What happens? What happens? Doesn't he afterwards the defendant, start calling people saying, just freaking out that he says, I think I killed?
Calls his uncle.
What does he say?
I think I killed, I shot a policeman, I think he's dead, I'm going to kill myself. Uncle says, don't do that, you have a family. A few minutes later, he's found underneath this wood pile where the officers converge on him. And
Does he try to shoot when he's?
At most, when you read their testimony, I suppose you could say there was passive resistance. They were pulling at him and tugging at him. And I guess, he didn't slide out that easy. He probably thought he was going to get killed, which is consistent with what all the shrinks say. Now, again, bear in mind that this is a diagnosed person who has got bipolar disorder with psychotic features, or even worse, schizoaffective disorder with psychotic features.
What year was he discharged from the Army?
2005. Now, and interestingly enough, when he was hospitalized in the Army, he had taken weapons there to the Army hospital with him for self-defense purposes as well. He took, I think it was a hammer and a pellet gun to the psychiatric facility at the Army. I mean, what did he think was going to happen when he brought the computer?
Am I on here? I believe, if I'm reading his history correctly, he was born in the Virgin Islands, am I correct?
Yes.
And he was a police officer in the Virgin Islands for about 5 years?
I may have been 5 years, it may have been a little less.
He was discharged because of mental problems?
He wasn't, no, he was discharged from the Army for mental problems. He quit the police.
I thought he had to leave the police department because he had issues.
He did have to leave the police department because he had issues, whether he was discharged.
I thought he left the police department because he thought the police were trying to conspire with the Masons to kill him, and a friend of his told him, well, based on that, friend not knowing that he was a little crazy, you should leave. So that's when he left the police department in the Virgin Islands.
I don't recall testimony of a friend saying, based on that, you should leave. But other than that, that's correct. He was getting dysfunction.
He wasn't discharged.
I don't recall any testimony that he was fired,
He quit.
per se. He quit, didn't show up, went to the hospital. His family put him in the hospital twice.
Let me get back to my point. Was he first diagnosed back then in the Virgin Islands with having mental problems?
Yes.
Okay. What was the diagnosis back then? Was he diagnosed with bipolar?
I
guess
think
I didn't call it that.
to be honest with you, I don't know that the bipolar diagnosis was made in the Virgin Islands. I know that was made at Fort Bragg. In the Virgin Islands, I know he was psychiatrically hospitalized twice in 2003. He was put on Haldol, which has horrendous side effects even for an antipsychotic.
You know how old he was, more or less, back then?
He was 34 in 2009, so that makes him 28 in 2003.
So when he left the police department, he was about 28 years old?
27, 28, yeah.
Okay.
So didn't he have an onset of these episodes when he was 19? Prior to working for
there's testimony that he was a good student and a good guy and a pretty normal guy in high school, and he started showing symptoms of the paranoia and the delusions and the weirdness shortly after that.
And that's a very, if for a bipolar, or again, I may be mixing terms, the idea of the onset for a male in their late teens, early 20s.
Yes.
But so when was the time in the military in relationship to being a police officer in the Virgin Islands?
He's hospitalized twice in the Virgin Islands in 2003. He was a police officer prior to that. He also worked at the Hovensa oil refinery in the Virgin Islands, and another island actually prior to that, and his problems got even worse there. He's hospitalized in the Virgin Islands in 2003. The Fort Bragg incident when he's in the Army occurred in 2005, so that's 2 years later.
So he gets into the United States Army with a previous diagnosis of mental illness?
It certainly appears that way, yes.
Okay. And he's then in there, and then he is seen. Does he ever engage in active combat?
No.
Because I thought there was something about Afghanistan.
No, he was never overseas.
How long did he serve?
Fairly short time. He did
Because
basic training. Right. He did basic training and enjoyed it. Then he started to decompensate again. He sees IEDs outside the barracks. He sees people crawling through the ceiling tiles. The rapper 50 Cent is out to kill him. There's a guy in his unit who looks like the rapper 50 Cent's brother who's out to kill him. his own superior officers, whatever, there's complaints from his fellow soldiers, they refer him to the shrink at the Womack Army Hospital or whatever, who concludes that's where he's diagnosed with bipolar disorder with psychotic features.
So the earliest, and again, going back to my point, and I'm trying to reach a certain point in my mind, the earliest point in time that there is some evidence of mental illness was after he left the police department, and you said that must have been when he was 27, 28 years old.
Well, no, I'm going to say the earliest point, the first hospitalization was after he left the police department. I think the earliest evidence that people were observing something mentally wrong with him would have been shortly after high school.
Okay, so we have a person who has basically confirmed mental illnesses since leaving high school, that's able to walk into a place and legally purchase 4 very powerful firearms.
That's correct.
And those firearms, did he have a receipt that he bought them?
He had receipts. He bought them in the Fort Bragg area when he was with his girlfriend up there.
Okay.
He bought them to protect them from the demons, right?
What?
He bought them to protect themselves from the demons.
The
people that are out to kill him.
He bought them for protection. I mean, I wish I could point to evidence that says he bought them to protect himself from the demons. He bought them for protection.
That's just a figure of speech.
Yeah.
His demons.
I'm being too much of a stickler here, I guess, but...
well, the main thing is that up till the age 34, he had no history, criminal history.
Absolutely not. And not only that, the testimony is when he's not decompensating, when he's not exhibiting the psychotic symptoms, he's a good guy. People like him. People love him. He's outgoing. He's funny. He's friendly. He's upbeat. He wasn't acting that way at his uncle's house.
What's the record about attempts to get mental health treatment and be on medication? Because so we make sure everybody that is mentally ill like this and has bipolar disorder can function in this society if they're on medication. Now, did he ever get medication from the VA? Did anyone try to help him get
I'll try to give you the history of the medication as best I can. In the Virgin Islands, they gave him Haldol. There's testimony, antipsychotic medications have horrible side effects, and that's why it's very, very common. All the shrinks are saying it's extremely common that people go off their meds, and that's a big problem. But Haldol is recognized as being the worst of all, or one of the worst of all. He had the Haldol made him feel like a zombie. He hated the Haldol, went off it. In North Carolina, when he was discharged from the Army, because obviously they couldn't keep him in the Army with his diagnosis, I think he was given a 7 to 10 day supply of antipsychotics. There's a period of time when he's with his girlfriend up there. There are periods where he's better, and then he gets off his meds, or periods of stress or whatever, he gets worse. Now, again, I want to illustrate something. I don't say this. I don't remember a case where I've ever actually said this, because usually what I have is a case where, either a case where there's no doubt as to guilt, that the person is in fact the person, like here, or I have a case where I'm arguing it's the wrong guy, or the evidence at trial, the defense argued it was the wrong guy. I don't think I've ever had a case before where I've argued that the evidence really shows, if you look at the context of this guy's entire life, this is a good guy. This is a good guy. I said in my brief he's been battling the demons of severe mental illness his entire adult life. And the state says to me, they like to backhand compliment me. They say, I artfully portray him as battling the demons of mental illness throughout his adult life. Well, I didn't artfully portray anything. That's what the evidence portrayed. And, this is somebody who, this is remarkable.
But still, and you're in your rebuttal, and so because we've had a lot about mental illness recently, isn't there a time that even, again, for a mentally ill person, say he went on a rampage like the person did up in Washington, D.C., and shot and killed 8 people? That's why I asked you about the circumstance, that to me what distinguishes this, and I'd like the state to, is that, not that he was provoked, not in that way, but that he was, essentially, he wasn't going off to kill people.
Absolutely. He was tased. I mean, there are
And again,
problems.
not that that's, but was the precipitating factor as opposed to someone that says, I am now going to go in and kill people children in a school, or go in and kill people innocent people. And so that circumstance of what precipitated it has to distinguish it, because you can't say just because someone's mentally ill, they're not subject
And I'm
to
not
the
saying
death
that. I
penalty.
made that clear at the very beginning. I'm not saying the eighth. Ricardo Gill, if I have time, I got to talk about 3 cases real quick. The one case I can think of that the state cited that has comparable evidence of pre-existing mental illness to this case is Ricardo Gill. Ricardo Gill, though, is the most, this is a case where he killed a woman for money, got a life sentence, then he strangles his cellmate to death. There was so the aggravators, all three great weight aggravators. There's CCP, there's prior violent felony of this prior murder, and I think there were 5 other felonies as well. Incredibly aggravated case, plus which there was a finding in Gill that his mental illness and his brain abnormality were not causally linked to the murder of either the cellmate Rosello or the prior murder. Here, they're incredibly linked. The state says that there's no linkage. Read the sentencing order and you'll find the linkage. Read the testimony of any of the 8 doctors, even including the state's Spencer hearing guy, and see if there's no linkage here. I wish I had more time. I really wish I had more time, but I don't. I'm going to sit down.
Thank you.
Good morning, Your Honors. May it please the Court. I'm Carol Dittmar from the Attorney General's Office, representing the appellee in this case, the state of Florida. And I'm going to pick up right where he left off, because the key to this case, the key to your proportionality is not was he mentally ill. There is no question about that. The key is to what effect was his mental illness, what effect did it have on him and on his functioning at the time that this murder occurred? And the trial judge...
Do you agree, though, and again, this is because there's Mr. Gill, in looking at this, the fact that he, as a mentally ill person, though, has gone through 34 years of his life without being violent, does that play a part in how we look at the circumstances of what occurred at the moment of the crime? Does that play at all? In other words, if you look at other cases where someone has no prior history, criminal history, what is it that happens on that day that ends up in a tragic killing where he never started out to rob somebody?
He's caught by a law enforcement officer breaking the law. And he knows it.
What is he doing?
He's carrying concealed weapons. And he knows it. And it's when the officer finds the weapons that this turns into such a bad stop. Is there
evidence in the record that the officer actually saw the weapons?
Well, Delgado, as he recounted it, said that it was when the officer found the weapons that the officer got angry and told him to move away from the cart, move away. He initially found the laptop. According to the way Delgado recounts it, the officer initially found the laptop and was accusing Delgado of having stolen the laptop, saying, so where did we get this? And Delgado was very offended.
Let me ask you, before he sees the laptop, did this start out as a consensual? I mean, he's going along, walking.
The testimony was, yes, that he's
homeless,
pushing,
and he clearly
he looks
homeless.
like he's homeless. He is disheveled. He's been walking through the rain and through the heat, and he's pushing a shopping cart with the bag in it. And there was testimony in the record that in this particular area of town, there had been a lot of crime committed by homeless people with shopping carts. So it would be natural that he would have reasonable suspicion to check out why this person is walking down 10 o'clock at night, walking with a shopping cart down the street. And Officer Roberts did not, there was conflicting testimony, but according to the video cams and everything, he did not activate his emergency lights. He just pulled over to the side of the road and he approached Delgado at that point. Now Delgado, and I do want to make the point before I get any farther, that the judge made a specific finding that he was not substantially impaired by this mental illness at the time of the crime. And the judge...
You said something about he pulled over, he hadn't activated his lights, he wasn't doing anything. Would you explain to me then, in that kind of stop, did Mr. Delgado voluntarily say, look in my bag, or did he look into Mr. Delgado's bag, and did the officer need something beyond, I pulled over just to talk with him, to look into that bag?
Well, and again, Delgado gives different conflicting statements, but he asks Delgado for identification when he first approaches Delgado and asks for identification. And then he's looking, and Delgado is saying, hey, it's okay. I used to be a cop. I was in the military, and he's trying to make it, according to what the mental health expert said in trying to analyze this out, Delgado is thinking, I look like I'm homeless, so I need to convince this officer that I'm really not a threat.
So he gave him the ID.
He hands over his ID. He has some of the witnesses, and it's true, the eyewitnesses were coming and going. It appears that he's looking at the ID with a flashlight, and he's asking him, well, what's in the bag? And Delgado at that moment, sometimes he says that he was going to tell him about the guns. He knew about the guns. He was offended. He says he started going through my stuff, and Delgado felt very disrespected by that the officer was not appeased just by hearing, oh, okay, you're former military, you're former officer, go ahead on your way. That he continues to ask him about his stuff, and which Delgado was very resented. Was very resented about, and becomes very angry, and it's this anger.
If we're going to listen to what Delgado said, though, it was he showed him the ID, he showed an ID, and the officer just started going through his things, and he never even asked, can I look in your bag or any of that. He just started going through his.
The way Delgado describes it is that he was very disrespected by the officer, is the way he puts it, and that he couldn't understand why the officer was being so rude to him and so mean to him. And he gets very angry with the officer, and it's this anger that causes the crime. It is not the mental illness that is going on, because he's very goal-directed. And I have to go back, and this is a case where I have a very different take on the evidence, and I am drawing everything from the evidence. And if you look at and the reason the judge credits Dr. Myers and his testimony on this substantial impairment is, if you read all of the evidence, which I'm sure you will from these mental health experts, Dr. Myers is the one that is really trying to figure out how Delgado is functioning mentally, whether, in the days and months leading up to this, and at the day that this happened and after this happened, his actual day-to-day functioning. And we talked about, and Mr. Bulletin talked about, well, he's living with his uncle, and all this summer he's just being crazy and acting crazy, and he's getting kicked out of places because of his mental illness, and the record doesn't really support that. He came down to live with his uncle when he and his girlfriend broke up.
The record doesn't support that the uncle told him he had to leave because he was scaring the children?
It doesn't support that he wasn't eating and that he was disheveled and he was acting crazy.
But doesn't support that the uncle asked him to leave because of his behavior was scaring the children.
Yes, he had very mild symptoms of, whether it's the bipolar, the depression, these symptoms, which include that he was pacing, he was constantly pacing, he had little need for sleep. Those are symptoms which he had dating back to being in high school, and which people talk about all the time, and not seeing that in him and not actually tying it to any type of psychotic episode. It was just a restlessness that he had apparently his whole life. His stepmother said that she saw it in him for years before she ever saw any kind of mental health problems.
Would you address the events on the evening? Is it totally clear from all of the medical witnesses that the taser was to the front? There was some mention of neck. Was it to the front or the back side?
The issue on the taser, first of all, you have two eyewitnesses. You have the state witness and you have the defense witness, who both testified they observed the taser incident. Both of them testified that Delgado did not in any way react to the taser, that there was no reaction whatsoever.
Was it from the front or the back?
Pardon me, sir?
Was the taser from the front or the back? I think that was the question.
He starts running away from the officer, so apparently he's tased from the back.
From the back, okay.
And where they find...
And do the individuals who witnessed this, are they in a position where they can observe whether the defendant had a weapon in his hand at that time, or what is the evidence that you say demonstrates the connection of Delgado with the weapon at that point, at the tasering point.
The state witness was a passenger in the car that had pulled over to observe it. And in fact, he's telling his girlfriend who's driving the car, hey, this guy's about to get tased. I want to see him react. So he was paying attention. The other witness, the defense witness, was going, I had the impression going the opposite way, and at some point he sees it and he is right about where it's happening when the taser comes out. He says he hears it, but he keeps going and he kind of looks in his rearview mirror and says he doesn't see any kind of reaction at all. So
I was asking about weapons. I didn't hear that mentioned at all.
Okay, so the weapons, the state witnesses is watching from the side. Both defense and state witness say that after the taser, immediately there's a big fist fight. They start having a fight. And according to the state witness, the officer is on the ground, lying on the ground on his back. The defendant is leaning over him, beating him. He says, I can't tell if he's got something in his hands. I can see he's hitting him about the head and neck and chest. Now we know, because we have medical evidence that confirms that the officer was the one that was not getting the better of it.
Was the officer shot with Delgado's gun or the officer's gun?
Well, the officer's gun never comes out of his holster. So Delgado has the gun and apparently has the gun on his person.
But there's no evidence. I mean, all this...
The eyewitness does not see the gun.
Nobody sees a gun coming out.
He does not see the gun until there's actually the shot. And he says he beats the officer up. This is the state witness. He beats the officer up, and the officer is lying unconscious on the ground on his back, and that he sees Delgado, at that point, he sees a gun in his hand, and he sees Delgado shoot the officer. We know that they were not fighting for the gun. There was not an accidental discharge because it was not a close shot. It was not a contact wound. It was at least a couple of feet away, we know from the evidence. And we know that the officer isn't getting his gun out, and that he has the injuries, and in fact, the gun had blood that indicated he'd been pistol whipped with the gun because there was blood his gun up inside the gun. So we know the physical evidence that there was a struggle and a fight before the shot.
Well, there's the issue that this was a purposeful shooting. I don't think that Mr. Bulletin saying that the shooting was an accident.
No, he's not, but I think this court has to consider the totality of the circumstances.
It sounds like you're arguing we're saying, well, it might be second-degree murder. No one's contesting that this is a first-degree murder case, but you said something that the judge didn't find that he was substantially impaired.
Correct.
But reading through everything the judge said, he said he was impaired, and then he also found he was under the influence of extreme emotional disturbance at the time of the event. And what I think I'm understanding now is that this defendant was trying to run away after having this I don't know whether it was consensual or not, but, getting his bag searched, running away, and I'm assuming then at the point he gets tased, is the police officer continue to run after him?
Yes. And he turns around and is able to overcome.
And doesn't he tell someone, and he tells the witness Freeman, that he said he started yelling, he was sorry, he insisted it was crazy, he didn't mean to do it. He complained he'd been shot with a taser, that he told him that the police were trying to kill him?
Yes.
I think I'm struggling with, on the one hand, we have clear evidence that we have someone here who has been suffering with mental illness since maybe before high school.
Yes. Well,
on the one hand, let me just stay with me. On the other hand, I'm also of the belief that one does not have to be mentally ill to become aggressive once you're tased. I mean, people do get aggressive once the tase goes on, and from what I'm hearing from the defense counsel, up until the point the police officer approached this gentleman, he was okay. He was a nice guy. He was just pushing a cart down the street. Well, and it was after the tasing that he became this aggressive.
I don't know that you can say he was really a nice guy until the tasing. He didn't become violent.
Right.
But he clearly was, and I don't agree with the characterization that he was just a good guy for 34 years and then all of a sudden this bad thing happens. I mean, he clearly had episodes in his life where we know his mental health was affecting his functioning, and then he had times where he functioned perfectly normally. And we know that in the days and months leading up to this, he had been functionally fairly normally. And he wasn't.
The point I'm making, I'm trying to get you to help me with, is it seems to me that it was the tasing that converted this person from a person who was cooperating to the point that he became violent.
I don't think it was the tasing. I think it was the fact that the officer was being rude to him as he took it and disrespecting him and going through his things, and he knew he was carrying concealed weapons, and he knew he was in trouble for that. And I think that's what it was more than the tasing, because all of the evidence suggests that he was not affected by the tasing at all. There is no evidence other than his own statements and what he tells his...
Was there any violence on his part before he was tased?
Well, he's punching the... before the fight?
Okay.
Before he was tased.
Before he's tased, there's no violence, no.
Right, so after tasing...
He was going to run away.
Okay, so after the tasing, that's when he turned around and confronted the officer, and there was a fist fight or whatever.
Right.
So it was the tasing that caused him to get angry, to the point that he became violent.
Well, it was the violence. I think the anger was before then, but I think the way he was going to deal with the anger was just to run away.
Okay.
And I think that was no longer an avenue when he got tased. But I don't think the tasing was the act that did it. I think it was I realize I'm in trouble because here I am and this officer is about to find me having these concealed weapons.
Except he's running away. He's not confronting the officer. I mean, we've had some horrible situations where somebody, the officer stops somebody, on the side of the road, and then the next thing that happens is that officer is shot, and before the officer does anything. That's not this situation.
Right, and I think that shows that he's not psychotic, and he's not being impacted by his mental illness, because...
Except that that's not what the judge found. The judge found at the time of this murder that he was under the influence of I never say it right. Yeah, extreme
under the
emotional disturbance.
Right. And I think the judge, he did find that aggravator, but when he rejected the substantial impairment, and he's crediting Dr. Myers with that, I think the difference is when you talk about, he's under the influence. If you think about someone who's under the influence of alcohol, they can have a 0.00001 blood alcohol level and still be under the influence of alcohol, but the law will presume...
You have been here...
Right, which is why I think you look at what the judge found with substantial impairment. Okay.
You've been arguing these cases for a very long time and doing an excellent job for the state of Florida. I am trying to think of a case during at least my tenure here with a more documented history of severe mental illness, not somebody that, we see so many that come and after the fact they reconstruct something and they're mentally ill. So now we have to get to whether, in my view, this is more like that case up in...
Okay. I think I know what you're... Let me explain it let me try it this way. So
do you agree that he is? Do you agree you've agreed that he's a severely mentally ill person that has been able to function in society and functioned on and off for 34 years?
The functioning is waxing and waning, and I do not agree that there is any evidence of the verbal mental illness before 2003. I don't think you go back to high school for that, because I think you have to look very carefully at the testimony. You have his wife testifying. He left the police department voluntarily to take the job at the oil refinery, is what she testified. So there's a lot of evidence about that. But if you look at his overall functioning and how he was doing day to day, what the mental health experts say is that mental illness, the bipolar, it will wax and wane, but it doesn't turn on and off instantly. It's not going to be triggered by being tased. It's something that takes days and weeks. And they said even that he's walking this 15 hours, this long trek, even that would not cause him to all of a sudden decompensate so severely from going to someone who's at the jewelry store saying, I don't really want to wait, but if I have to wait for my money for, completely appropriate the way he's reacting in that stressful situation. They said his no mental illness is just going to come home and so suddenly that by the time he gets to Tampa that night at 10 o'clock at night, he is going to be reacting to what's happened. And the mental health experts agreed, with the exception of Dr. Mayer, who says he was psychotic this whole time. And, you know, he's having this goal-oriented. He wasn't actually going to the VA. He was going to an apartment complex close to the Tampa VA because he had read up about this how apartment complex works with veterans and will negotiate rents, and that's why he had gotten all his stuff from his uncle. Now, when he gets kicked out of his uncle's house, and we can talk about the reasons for that, he goes and he lives with a friend of a friend who doesn't really, says yes, he's up pacing at night, but he's very nice, conversational, talks to people. He has different options available to him. He's going to the library on the computers, checking for jobs, checking for housing. He's frustrated with the VA in Pinellas County because they are not giving him the services that he thinks he deserves from them. He wants to try to work with the VA in Tampa because he's heard good things about them. He does the research and finds this apartment complex that will advertise to work with veterans, and that's why he says, I want to go get all my guns and my laptop in case I need to pawn something. I want to have everything with me when I get over there. He's very goal-oriented. He knows what he's doing. And Dr. Myers is the only expert here who went and pulled his cell phone records and said, how much is he using his cell phone over these days and months leading up to this? It's normal. It's not what you would expect to see in somebody that's mentally ill. He looked at his financial records. He says he gets his disability, his whatever benefits from the veterans he gets monthly, and he's able to make that last. At the end of the month, he's still got money in his account. So he's able to function in these day-to-day things. He's able to be very goal-oriented. We do know that he has a personality, which, yes, it can be fun, and a lot of people find it very attractive, but he also has a personality of saying, I don't put up with people who don't respect me. We know that when he got these 4 guns in 2006 and 2008, after he had been discharged from the military, he lied and said he'd never had any mental health issues. He got into the military by lying and saying he had never had any mental health issues, and these are times when he's functioning normally. So, there are these shades of things all through, but it appears that if you really look at all of his symptoms up until the time, and especially over the summer, they're very mild. He's not having any kind of psychosis. He doesn't tell anybody that he thinks this officer is coming to get him to join the Masons. He doesn't offer anything like that. He says he caught me and I had these guns and he disrespected me and I want a lawyer because I'm the victim here, and he had that attitude. So the mental health, experts really...
You want to listen to me?
Yes.
Take a breath.
Okay.
Calm down.
Okay.
I got a headache.
I'm sorry. I apologize.
He could have shot the second officer, couldn't he? He was close enough to hit him.
Yes. In fact, in the testimony about the second aggravator doesn't just come from the officer there at the scene, because the state witness, Mr. Farmer, who had his girlfriend pull over, he's the one that calls 911. And in fact, he actually is a witness to the second aggravator as well. And he is telling the 911 officer, it's right there on the 911 tape. You can say he's a 7-time convicted felon, but he's on the 911 tape saying, oh my God, he's going to kill us, he's going to shoot a second officer. So this, and as it was described from Mumford, and what Farmer says is, at that point, we do know about the gun, because Farmer says he reached into his bag and he takes out the big gun, because he's got an assault rifle in there. And he takes that out, and that's the gun that he uses, and he gets in the 3-point stance like you're taught in school, and that's what he does with the second officer. And the second officer dives behind a dumpster to avoid getting shot, and that's how Delgado
affects his escape. Did he shoot at the second officer at all?
He did not shoot the second officer.
So if he's thinking so clearly and so plainly, he knew he killed the first officer, and the second officer there,
he wants to get away, and he was able to do that. He got away.
Couldn't he just shoot him and get away better instead of him?
He really just wanted to get away, and he was able to do what he wanted to do because the officer dives and he is able to run away. So he was able to get his escape. Now he runs and hides in the woodpile, and when they get the canine, and one of the things when he comes out and when they're pulling him out, what he's saying is, I'm sorry, I didn't mean to do it, I'm one of you and I'm mentally ill. And all of a sudden this man who has never had any insight into actually being mentally ill, he is somehow aware enough that he's already talked to his uncle on the phone. So you're saying
all these years he was pretending?
No.
This is just a pretext?
No, I'm not. I'm just saying you have to look at how his mind was functioning at the time, and it was functioning pretty darn well at the time. He knew what was going on. He calls his uncle.
Your argument then breaks down to me is that every minute this defendant has to be pretty much a babbling idiot in order to demonstrate that he's having any kind of psychological problems going on.
No, not at all. Not at all. Not everybody.
Well, I mean, that's what it seems to me, because you pick out every little thing and say, this shows that he's functioning fine. But how in the world can you say someone is functioning fine, who's been put out, who has no money, who's got to travel or chooses for whatever psychological reason to travel 15, 16 miles, was it, that he walked in the heat? And was it raining part of that time also?
Apparently, because at one point when he calls his uncle, he said it was raining.
Okay.
But he knew where he was going.
And all of that demonstrates a good
I'm sorry?
Didn't he have a bad leg when he was doing all this walking?
He apparently has a bad knee, although, again, the evidence about his physical problems is not real. We know that he has physical problems. We know he was treated for neck, but we really don't know what the issue is or what the treatment was. And we know that he has gone these 5 years where he's been able to function, and he really isn't seeking mental health treatment. He's not getting medication, he's not taking medication, and he's able to, again, just do day-to-day things. And if you had him at the scene of the crime, somehow giving some demonstration of psychosis or having somebody say, well, he's making statements or he's taking actions which show that he's not all there, which shows he's acting under something that's going on, there would be evidence of that, and there isn't. And all of the evidence, when you talk about the extreme disturbance and you talk about all the mental health testimony, it all relates to the fact that he has this history and he was under a lot of stress. He was under these stressors at the time this occurred. But they're not looking at his actual actions and behaviors as Dr. Myers is. And that's why the judge credits Dr. Myers, and that's a credibility determination, on the substantial impairment. So I think you really, and it is very tricky because you can pull little facts out and say, well, this helps me and this helps me, and obviously Mr. Bulletin can do the same thing. But that's why we look at the trial court findings, and the trial court making the finding there was no substantial impairment based on him finding Dr. Myers to be credible is, I think, what has to be the key to this court's proportionality. Now, I do want to address, and I talked a little bit about the second aggravator, this aggravating factor, and I agree with Justice Pariente. This court has said HAC is very serious, CCP, they're very weighty. Those are weighty aggravators because they set the normal murder apart. But this isn't, the murder of a law enforcement officer is already set apart in a class by itself. It is not just a normal murder that needs another factor to set it apart. It is a horrendous crime. You have not just the individual that you're killing, but you're killing part of society. You're killing everything that is good and right and just in society, because the men and women behind that badge are community heroes. And when you take that life, it should be considered an egregious crime and a crime against all of us. And that's the reason you really have to have substantial mitigation that was impacting him substantially at the time of the crime in order for this court to find that it's disproportionate. So I would ask this court to please affirm the judgment, the convictions, and the sentences imposed below. Thank you.
Thank you. Rebuttal?
If the state's not arguing automatic death sentence for a law enforcement officer case, then I don't know what they're arguing.
Well, they're saying, what she's saying, if you want to address it, that you have impairment, but the judge didn't find substantial impairment.
On the law enforcement officer, just look at Hardy. That's the case that comes way closer than anything else. The state likes Altersberger. Look at Hardy. Look at Altersberger. Look at the judge's sentencing order in this case. Yes, the judge credited Dr. Myers on impaired capacity. He still found it. He still gave it moderate weight. Yes, he found Dr. Myers the most credible on impaired capacity. Do I think he was right? No, I don't, but okay, he did that. But he did just the opposite on extreme mental or emotional disturbance. He clearly found that it was at the time of the crime. He gave it substantial weight. He wasn't basing that on his history because he found his history as a separate non-statutory mitigator. Look at the judge's finding on the separate non-statutory mitigator of the stress that he was under. I want to talk about the aunt and the uncle, but let me first talk about Dr. Myers never even saw the defendant, never saw Delgado until 2 years after the crime, after he had been stabilized on antipsychotic meds. The doctors who saw him right around the time of the crime were Maher, Stein, who was hired by the state and who testified for the defense in the penalty phase and dispenser hearing, and said this crime wouldn't have occurred but for the mental illness. And I think the third one was Ruiz. I think a very important witness in this case was the jail psychiatrist, Hernandez, Jose Hernandez, who saw Delgado the day after the crime and immediately said, I found that he was very psychotic and delusional, and I prescribed antipsychotic meds, and I monitored him every day, and I had to up the dose, but eventually, yes, it stabilized him. The doctors testify, even when stabilized on the meds, he still believes his delusions, but they're less intense.
Do you agree with the assessment that there was no violence here until the point that he was tased?
Yes, I do.
And there was violence before? There was before he was tased?
There was no violence before he was tased. He was running away. And the state said that there's no evidence.
Why isn't it the tasing that caused his violent reaction instead of his mental illness?
It may well have been, but I got to address something the state said. I got time. The state says there's no evidence that he was affected by the tasing. How about the state's witness, Richard Farmer, who's the one that they're relying on for a lot of their argument that this was a deliberate crime, even though the jury didn't find that and the trial judge didn't find that. Farmer testified that he pulled the taser out of his shoulder, and that when he told investigators, when he was questioned after the incident, the man did look like he'd been tased, and he was hopping around. What about the state's own witness, Dr. Taylor, who testified for us in the penalty phase in the Spencer hearing, but when he was a state witness on insanity in the guilt phase, testified that he wouldn't be at all surprised if Delgado was momentarily stunned by the taser. So there's clearly evidence from the state's own witnesses that there could have been and likely was some effect from the taser. Unfortunately, I wish there had been more effect from the taser. I wish he wasn't mentally ill or whatever, or he got stuck in his dreadlocks. I wish that it would have completely incapacitated him, because then Corporal Roberts would be alive and Humberto Delgado would not be on death row. He'd probably be hospitalized. But the taser had some effect, certainly some psychological effect, if not a physical effect. Did it completely cause this crime? No, it didn't. The main contributing factor here was his mental illness. Even Dr. Myers said that this was a multifactorial crime and didn't deny that his mental illness played a role in it and that the stress he was under played a role in it. Read the judge's sentencing order on the stressors, on what his life was like in the months and weeks leading up to this crime, and then say that well, he was mentally ill, but he was just doing fine this week when he happened to kill a police officer. Look at tell me that people who are psychotic, who have bipolar disorder with psychotic features, they get better when they're off their meds. They get better when they're under stress.
You're out of time. Thank you for your arguments. Court is adjourned.
All rise.